Good morning, Judge.
Good morning.
Good morning. I just need to know that all parties, all the legal representatives are present.
My lady, Norman Aronson, I appear for the applicant, the SIU, together with Ms. Sandra Fries on the instructions of the SIU and Ms. Stella Zondi of the State Attorney.
It's not Fries, like a Fries for meat.
Thank you, Mr. Aronson. Right, so then we're looking at for the first respondent.
My lady, I am Louisa Macapela. Although I appear alone today, I am on brief from ENS with my learned senior, Mr. Azar Bam Essi, who will not be joining us today.
So you are on record for the first and second?
For the first respondent only, my lady.
Macapela. Right, and for the second respondent?
My lady, it's Sue Hayes from ENS. We appear on a watching brief for the second respondent.
Okay, then we have the third respondent.
Good morning, my lady. It's Van der Vyver H from the Joburg Bar for the third respondent.
Thank you. Fourth respondent. Who's here for the fourth respondent? We not yet have a, this is Panelo Pele Architects. Nobody here on record yet, or nobody present yet?
I do not think they've logged in yet, my lady.
Okay, I'll just leave that open. And then fifth respondent.
My lady, we formally appeared for the fifth respondent, but we've received no instructions for the fifth and the 12th. We understand that the attorney, Mr. Sven Lawrence, is on the call and should represent them. We haven't received anything from them.
Although you were previously on record for them.
Yes, my lady.
Okay, so at this for today's hearing, you're not actually appearing for them then?
Yes, my lady.
Is there somebody present for the fifth respondent then?
Indeed, my lady. It's Sven Lorenchik from LLP Attorneys. I have received instructions to withdraw in the matter, and I'm simply appearing today as a courtesy. I will formally deliver a notice of intention to withdraw in due course.
All right. So, and is anyone present for the fifth respondent then?
I'm not sure, my lady. I will. I'm not sure.
Sorry, what's your name again, sir?
It's Sven Lorenchik. I'll spell that for you. It's Laurenchik.
Okay.
And my lady, that would be the case for the 12th respondent as well.
So, Mr. Lorenchik, were you also then the instructing attorney for the 12th respondent, Mr. Hurdes?
Yes, my lady. I was indeed.
Okay, so 5th and 12th. And is there anyone present in person for the 12th respondent?
Not as far as I'm aware, my lady.
Okay, good. You are then asking to be excused, Mr. Lorenchik?
If I may, my lady.
All right, you will then file that formal notice to withdraw.
I will indeed.
Yeah. All right then, Mr. Lorenchik. Well, does anybody have any objection? Anyone else that wants to say anything? No.
Thank you, my lady.
And you are excused, Mr. Lorenchik.
Thank you.
Thank you. Sixth respondent.
As it pleases your lady, I'm appearing on behalf of the sixth respondent. It's Klopper, initial is JC, on behalf of IRS attorneys, or briefed by IRS attorneys.
Sixth respondent, right? Seventh respondent.
As it pleases the courts, my lady, I appear on behalf of the seventh respondent as junior. My senior has just been kicked out from the meeting, but I think he's trying to reconnect. My senior is Kennedy Tatawani.
Sorry, what's his surname?
Tatawani. Tsane.
Can you hear me?
I can hear you now, my lady.
Good. Just spell your senior's surname for me, please.
Tsane. Tatawani.
I've got as far as
I've now been reconnected, my lady.
Sorry, who is this? Oh, Mr. Tatsawane.
Yes, I'm now reconnected. Thank you, my lady.
Okay. Tatsawane. Advocate R. Ramatsabela. That's for the seventh respondent. Eighth respondent. Who is anyone present for the eighth respondent? That is Dipatse Trading and Projects.
They're not opposing, my lady. There's no papers.
No appearance. Eighth respondent. Unopposed. Ninth. I think they also probably one of those, aren't they?
Yes, my lady. Same 8 and 9.
And the 10th respondent?
Please, my lady, I, Lawrence Hardis, appear for the 10th respondent. My junior is Ms. Govender, Tanil Govender. And in respect of the 10th respondent, we are briefed by BBM attorneys who are present as well. And my junior is present as well.
You're also on record for the 13th, aren't you?
Yes, my lady, but that's with a different attorney. In relation to the 13th respondent, I have the same junior, but my instructing attorney is VNA attorneys, Victor Kwashu and Associates. So for the 10th respondent, our instructing attorney is BBM attorneys, but for the 13th, it's VNA Incorporated, my lady.
Thank you. And then we're looking at the 11th.
As the court pleases, my lady, I appear for the 11th respondent, P. Ellis, from the Pretoria Bar. I'm assisted by my learned junior, Mr. Ernest Malherbe, and my instructing attorney is Mr. Tobias Bron, who is also present here.
Okay, and the 12th respondent is one of those that is not opposed, is it right?
Lady, it's the 14th, the 12th is
the 14th. The first 8, 9. Yes, the 12th and 14th are not here.
No, my lady, the 12th is there. The 14th is not. I beg your pardon. 12th was Mr. Lorenchik. I beg your pardon.
Yes, that's right.
Thank you, my lady.
And appearance, and so I'll just that's the 14th. So then that covers everybody, I think. Just make sure, just go down one more time. We've got Advocate Arendse with Ms. Fries for the applicant, Ms. Alma Capella for the first respondent, Mr. Hayes, Ms. Hayes, sorry, watching brief for the second respondent, Mr. van der Vyver, third respondent, Mr. Lawrentick was for the fifth and 12th respondent. He's withdrawn and been excused, and he will serve his notice to withdraw shortly. Mr. Klopper, you're here for the sixth respondent. Mr. Satsawane, with Ms. Ramatsalela for the seventh. No appearance for the 8th, 9th, 12th, and 14th. And then for respondent number 10, it's Mr. Hodis with Ms. T. Govender for the 10th, as well as the 13th, albeit instructed by two separate firms. Have I covered everybody? Has everybody been placed on record?
Yes, my lady.
Thank you. Right. Mr. Arendse, where are we going with this today?
My lady, I'm sorry to interject. Can I ask that all the councils that are not on board now switch off their mics and cameras so that we can control the connectivity?
Okay, so are you saying that
I'm not addressing you now? Can switch off their mics and cameras so that we can.
Yes.
Thank you.
Right. Mr. Arendse?
My lady, good morning.
Good morning.
My lady, we have instructions to, with your leave, keep this week open so that we can argue the matter. The relief that we seek comes in two parts. The one is the declaration of invalidity, unlawfulness, unconstitutionality of the contracts/awards of the service providers/contractors, and the other one relates more to the money aspect of the case, where we're asking for a debatement of account in respect of the disgorgement of profits. And that is also where most of the disputes of fact arise in relation to Ms. Motara, our expert, her report. And we submit that be deferred to a second leg of the case, so that we focus this week on the validity of the contracts. As the matter stands, you would have seen from the roll call that there are a number of respondents who do not oppose, and then it's also opposed by some others. There is a large measure of overlap on the side of the opposing respondents. The issue of whether this should have been heard as an action, in other words, should have gone to trial in anticipation of alleged or perceived disputes of fact. So action versus motion, that is raised by all the opposing respondents. The issue of the SIU delaying instituting these review proceedings is raised by, according to my notes, the 6th, 11th, and 13th respondents. The issue of Mr. Cornelius de Toy from the SIU, the lead investigator, that his affidavit contains hearsay evidence, that is raised by 6, 7, 10, 11, and 13th respondents. The issue of non-joinder is that we haven't cited various or the relevant officials. That's also raised by all the opposing respondents. And obviously, the issue of the setting aside of the contracts or the awards, that's challenged by all the opposing respondents, and then also in relation to the just and equitable relief. So, my lady, we submit that we can, starting today and for the remainder of this week, deal with all those issues and the relief that we seek in paragraphs 1 to 4, that's the declaratory relief in our amended notice of motion, which is at we're just trying to get a screen going here, my lady, with case lines.
File 3, it's 01140, page 47. 01147.
Thank you.
You're talking about your amended notice of motion.
The amended, the one of I think 4 April this year. So we would submit the relief that we're going to ask your ladyship for is paragraphs 1 to 4, and the alternative relief contained in paragraph 7 of the amended notice. Now, your ladyship would have seen quite a number of documents have been filed late onto case lines. Now, given our instructions, my lady.
Yes.
I don't know.
Ms. Zondi, your speaker is on. Sorry, Judge. Thank you.
Okay, thank you.
Sorry, ma, that's our instructing attorney, my lady.
All right.
So, my lady, given that these are scarce judicial resources, I think all my colleagues who are participating today will also acknowledge that your colleague, Judge Madiba, said that we must make every effort to keep these dates open, because even when we looked at next year, February, March, it was near impossible to get all counsel to be available on those dates. So from our side, we are prepared to, subject to your leave, to concede heads that have been filed late and or answering affidavits that have been filed late. We ourselves, we asked for condonation for a late reply. We were 2 weeks late, my lady. But we, as you would have seen from the papers, we did file our heads of argument timeously. So we submit in that regard that there can't be any prejudice to any of the parties. There wasn't any subsequent papers or affidavit that had to be filed. They had a month within which to file their heads of argument, and most of them in any case took more than a month, either by private arrangement with us where we indulged them, and we said no, that's fine. So we don't have an issue with that. The only late application that we have opposed relates to the 7th respondent, my lady. They filed a supplementary affidavit on the 2nd of, I think it's at 101, the 2nd of August.
No, it wasn't. That's
sorry, on the 12th of the 12th of October. Yes, thank you.
2nd of August will relate to, I think, the 6th respondent.
The 6th respondent. Yeah.
And you are not, you're not opposing that, obviously.
We're not, my lady. So it's the affidavit that that was filed on the 12th, introducing wholly new issues. Just in summary, that this tribunal is not a court of law and cannot determine judicial review, that we must apply PAJA, the delay point which have been raised by the other, and then some kind of estoppel. So that we oppose and we submit should be disregarded and be dismissed by your ladyship. Otherwise, my lady, to the extent that there is a large measure of overlap on the part of all the opposing respondents, we would submit with your leave that we proceed to argue these matters, and that we use the days that have been set aside for the hearing of this matter, my lady.
Just to recap then, the application by the sixth respondent for the late filing, I think he was late by a day or something, of his supplementary affidavit is not opposed.
Yeah.
The application for condemnation by the fourth respondent, who threw in his heads reached me at 3 o'clock on Friday afternoon, together with a condemnation application. You're not taking issue with that either.
My lady, can I just not withdraw, but to just clarify or qualify by saying we're not opposed to it. To the extent that any new issues are raised, we will address you in the main on all the issues raised properly, timelessly by all the respondents. And to the extent that there are new issues, of course, we'll get an opportunity in reply, my lady, to deal with it.
Okay. So the only one that you're going to be opposing is the one by the seventh respondent to file that supplementary affidavit introducing now a new defense.
Yeah.
When you say we must carry on, are you saying that we must not hear that one now, or hear it and then they must sort of plead over and carry on with the main application?
Yes, my lady, we don't see why it should delay these proceedings, but it's subject to your ladyship whether you want to deal with it upfront as a standalone interlocutory and rule on it, or whether we should just proceed in the main and deal with all the issues and deal with it at the end.
Well, I think probably the more logical way is to let's hear that argument first, because the issues are such that one should hear that up front. And my view, and I'm going to hear from the others now, is that we then continue with the main application, and then I have everything before me and I will make my rulings ultimately. I just want to hear from the others. If the respondents can just one tell me what they think. Firstly, sorry.
May I please record, my lady, for the seventh respondent. Our submission, my lady, is that we agree with our learned friends for the applicant that we do not need to delay the hearing of the application. So our submission is that the applicant should present its case in the main and deal with its opposition of the application filed by my client, and because all the issues raised in that application have been dealt with in their answering affidavits. We have replied to it. And some of the issues, in fact, the issues raised in that affidavit have already been dealt with in their heads of argument. So we don't think there should be a split in the sense that we should just argue the whole case and then we'll deal with it when we get to it as well. Thank you, my lady.
Thank you. I think before I just ask everybody, it's a bit of a mission to go around the table, so to speak. Mr. Arendse, there's just something else I need to canvass with you, or clarify with you. Initially, you want the declaratory order, and then you included the just and equitable remedy by way of your amended notice of motion. In your heads, I see that you say your main focus now is to ensure that, or to get an order to get the respondents to do a statement and debatement of account for the purposes of disgorgement of profits.
Yes, my lady.
Is that what you're now asking?
Yes, my lady.
Why I say this is, if you're not proceeding with the overcharging aspect as you initially did, then is there a need to consider the expert reports?
My lady, with respect, yes, we are not abandoning the overcharging issue, because your ladyship will know, it's well established, is that overcharging is also a species of review. So to the extent that it also constitutes a review ground, we will persist with that, my lady. But we've abandoned the other part where we've specified the amounts that have been overcharged, etc. Whereas the focus on the second part of the case will be, and this is according to the well-established all-pay principle, that parties shouldn't benefit from illegally awarded or obtained contracts, and if they shouldn't profit from illegally obtained contracts. So that would be the second part of the case, maybe. And once a debatement and statement of account, once that process takes place, then one will be able to ascertain that. And that was also a view that was very recently adopted by the SCA. It's not a case that's mentioned in our heads of argument. It's Siangena versus Prasa. I think it's the 7th of
we can deal with that when we get to it. I just need, for the purposes of clarity and comment by the other parties, what exactly, because if, I'm trying to ascertain whether there's going to be a need to refer anything to oral evidence, because there is a dispute regarding the expert reports, and obviously findings cannot be made until we hear these experts. The 10th and the 11th respondents have raised disputes regarding the accuracy, reliability, and so on of Ms. Motara's report. So I'm trying to chart the way forward and how we're going to handle this in respect of that aspect.
Yes, my lady. Obviously, the disputes of fact in relation to the report would certainly, in this first part of the case, be narrowed quite considerably, and we submit can be resolved on the papers in the usual way by applying Plascon evidence. But in relation to the actual rands and cents and calculations or miscalculations allegedly by Ms. Motara, that would relate more to the second leg of the case, my lady.
Thank you, Mr. Aronson. All right, let's hear the respondents. Firstly, with regard to proceeding with the main application and dealing with the 7th respondent's application for filing this additional affidavit in the course of the arguments. So, shall we go down the line and start with Ms. Makapela? Do you have anything to say?
My sincerest apologies, Judge. I was just messaging my attorney and I missed that last part of your question. Going down the line with the respondents with regard to?
Yes, with regard to the proposition that we simply carry on with the main application and the 7th respondent's interlocutory will be dealt with when we get to it in the course of dealing with the arguments in respect of the main application. Do you have anything to say?
I have nothing to say to that, my lady, in that regard. However, I would like an opportunity to say something with regard to our counter application at a stage after this, just before we get started with the main application.
Okay, well, let's do that now, you know, and because you're first in line so everybody can respond.
Yes. So, milady, our understanding was that the 6th respondent and Mr. Klopper could come in after myself, was that they were going to withdraw the counter application. We had asked them to tender costs, and they had not responded to that. So if we could just deal with that so that we could be excused if the counter application is going to be withdrawn, and we don't have to sit through the entire week if, you know, our application or that application that implicates us has been withdrawn.
Okay. All right, thank you. Then we'll just we'll deal with it again when Mr. Klopper, I see you're on. You know, deal with it and dispose of it now.
Yes. May I quickly yes. Answer to that?
Yes.
There's no indication that the counter application will be withdrawn. Your lady would have seen it is a purely 100% conditional counter application, conditioning on what is conditioned on what a possible judgment or order could be. So at this particular case, it's simply a conditional application which could come into effect depending on the judgment or could not depending on the judgment in future. It is similar to a third-party notice, and it is not something which is required to be dealt with at this stage by the tribunal, because that will also that could only come into effect depending on what the tribunal's judgment is in this particular matter. And that's how we try to indicate to the representatives of the first respondent. We are not moving for that for the counter application at this stage, and we won't not be able to move for it before a final order or judgment is made on the merits of the application that could trigger the possibility of such a conditional claim.
I think Ms. Makapela's concern is that she's going to sit through a week of a matter where she's not going to be involved. What's your view on that?
She's definitely not required to be present in the proceedings if she does not wish to participate on the merits of the main application by the SIU, because we are not, and I place it clearly on record, we are not moving at this stage the counter application, which is conditional. We cannot move it before we've received a judgment or an order from the tribunal, if applicable.
And you're not also participating or opposing on the merits?
The first respondent, no. But we are.
The second respondent.
The first and the second are not participating at all in the merits.
Yes. So would the same apply to you then, that it's not necessary for you to sit through the week?
For us, on behalf of the sixth respondent, no, we are opposing the merits.
Okay.
We filed substantial opposing affidavit. Your lady would have seen that.
Okay. All right. Then, so does that answer your question, Ms. Makapela?
It does not, my lady, but it does, I guess, clarify the situation. I think we were under some sort of indication that that would have been the case, that it would have been withdrawn. But if Mr. Klopper states that that is not the case, then there's no use in us fighting that they indicated that.
Yes,
we may
and
have
they
been
will only
mistaken.
move this application once a judgment has been given in this matter.
Yes.
If at that stage they're still required to move the application. That's in a nutshell what he's saying.
Thank you, my lady.
Okay, thank you. So are you then asking to be excused for the rest of the hearing, Ms. Makapela?
We are indeed, my lady. With the exception, my apologies, my lady, with the exception of arguing costs should it get to it after the fact. But in terms of the entire hearing, we do request to be excused from that. So we will hear from the registrar that when those arguments are going to be made.
With regard to costs?
With regard to costs, yes.
Well, if you don't settle that between yourselves, because it will basically be costs for today. Yes, if that is not settled, then obviously you'll be given a chance at the end to address on costs. Perhaps, a discussion between you and Mr. Klopper might make it unnecessary for you to then argue the question of cost at a later stage.
Thank you, my lady.
All right, then.
So we are excused. My apologies,
yes.
lady. So we are excused. Okay, thank you.
See, the screen is frozen. Can you hear me? Are you able to hear me?
We are, my lady.
Good.
Yes.
I was just saying that Mr. Klopper and Ms. Makapela can discuss the question of the cost for today. And then if they cannot resolve it, then perhaps Ms. Makapela will be allowed to address on costs at later in the week. Mr. Klopper, are you happy with that?
Yes, my lady, I think that's the practical way. The issue of cost can only arise after the judgment of this tribunal. So we accept that the first respondent's rights is reserved in that regard, and we accept that. We are not going to argue any costs relating to the first respondent in the main application. That will only become applicable, as I said, possibly if the conditional counter application is proceeding. We can give insurance to the first respondent that we're not going to ask anything relating to costs while they are not present.
Well, I think the boot is on the other foot. She wants to know what's happening to her costs for today.
Yes.
So that's why I say perhaps discuss that, and if you cannot resolve it, then we will hear both of you later in the week.
Yes, that's practical, we submit.
My apologies, my lady. I don't mean to interject or to make this longer than it should be, but I did just receive a message from my attorney, because it looks like there's been a bit of a confusion. The entire reason why there's been this request from the first respondent to deal with this is because we received a letter from the sixth respondent indicating all that I'm saying. And then when we requested them to then tender costs for the withdrawal, that is when we didn't receive a response. So my coming here and talking about the counter application is premised on a letter received from the sixth respondent indicating this, and that is why we're talking about costs and being excused from the hearing and whether or not they're going to withdraw.
So Mr. Klopper doesn't appear to have been placed in possession of that letter then?
I just realized that, I think now, my lady.
No, my lady, with all due respect, we do have a copy of the letter. The letter does not talk about withdrawing. The letter confirms what I've put on record, namely that the issue will only be dealt with after judgment because it is conditional on what is contained in the judgment of the merit. That's what was stipulated right from the beginning for the first respondent in our letter.
So it's not a question of the application or the counter application being withdrawn.
No, my lady. It's simply premature to deal with it until after judgment on the main application.
Right, Ms. Makapela?
Perhaps my LLB just is a different sort of LLB, my lady. That was not my understanding of the letter. There was even mention of the fact that it would be withdrawn and instituted in the High Court instead. So unless I misunderstood, or we misunderstood the sixth respondent's implication in the letter, we apologize for that. But that was our understanding, that they were saying they wish to withdraw it in the special tribunal and they are going to go launch it before the High Court. And so unless I misunderstood that, unless our attorneys, all of them, misunderstood this, then I guess that can be, we can agree to disagree on that.
Well, lady, we will deal with directly with the first respondent in that regard, and we will take it from there. And only if there's a necessity, we will specifically approach your lady on that issue if necessary.
All right, good. Then in that case, Ms. Makapela, you're excused from further attendance after this hearing for the rest of the week.
As the court pleases.
Thank you. Right, then we go back to Ms. Hayes. Do you have, well, you're on a watching brief, so I take it you don't have any comments with regard to the proposals for the way forward in this matter.
That is correct, my lady.
Thank you. And then Mr. van der Vyver.
My lady, I've got no objection to what has been proposed. Just one comment. It was my understanding that if, I think it's the seventh respondent, if the jurisdiction point is good, it would dispose of the matter. But maybe that's my only comment to make, is it would have seemed prudent to me to deal with that first. But as I say, I'm in your ladyship's hands. We've got no objection to the way it is proposed at the moment.
Yes, you know, in the interest of time and the fact that we have so many counsel, it is almost an impossible task to get everybody together at the same time. That was what I proposed, that we hear that application and then they can plead over, so to speak, and carry on with the main application. When it's time for me to do my ruling, then obviously I will deal with that and decide what my ruling in respect of the main application will be, depending on what I rule with regard to the seventh respondent's application.
I'm in your ladyship's hands.
As it pleases the court, my lady, I appear on behalf of the fourth respondent.
Just a minute, just a minute. Thank you. Yes, the fourth respondent is, where are we? Sorry, who's here for the fourth respondent? I don't have Mr. Keller.
That is correct, that is correct, my lady. This is Keller with Mr. Siboba. Thank you. My lady, in fact, I've heard the seventh respondent, but my suggestion is that, my lady, I've noticed that many of us, in fact, have raised preliminary points.
Sorry, your line is very muffled. You said many of us what?
Many of us as respondents who have raised various, in fact, preliminary or points of law in as far as this matter is concerned. However, my lady, my suggestion is that your ladyship perhaps deals with the interlocutory application by the 7th respondent without delving into the merits of the main, in fact, SIU application. In that, my lady, that will create an environment for us also to deal with those preliminary issues before we delve into the merits. So, my lady, in essence, all I'm suggesting is that, my lady, the ladyship confine herself, in fact, to the interlocutory and without hearing, in fact, the merits, because we would like also, my lady, to raise issues that will have a determining factor as to whether we go to the merits or not in this matter. So in that regard, my lady, I partly agree with the suggestion. However, my lady, amplifying it under those, in fact, submissions.
And are you suggesting that we do that this week, that we hear it and give a ruling and then defer the merits to another day?
Yeah, that is my suggestion, your ladyship. If your ladyship has regard to the number of points of law that have been raised in this matter, there are so many, my lady. With me, for an example, I've raised around 5, if not 6. And those issues have in fact a bearing as to whether we will delve into the merits or not. So, my lady, we've asked the court to pronounce on those issues. For an example, my lady, one of the issues that we have raised, in fact, is the non-compliance with Rule 53 in terms of the principle of legality, of which this particular review has been launched. So we're going to take you through that, in fact, and also align ourselves with, in fact, the decided SCA judgments in that regard. So, my lady, those issues, if we are correct or if your ladyship finds in our favor, of course, my lady, they will have a bearing as to whether we will cross the fence of hearing this matter or not. So, my lady, all I'm suggesting at this particular stage, let's deal with those particular issues. Let's ask, in fact, the court to pronounce on those issues, and then thereafter we see as to whether we will ever go into the merits of this matter. Thank you, my lady. Another example, my lady, in this particular instance, my lady, that perhaps is very connected to what I'm suggesting is that under principle of legality, my lady, this particular matter, as one can see, in fact, is dating back to the first quarter of 2020. However, the review application, in fact, was launched late in December, around the 14th, if I'm not mistaken. So, my lady, there hasn't been any explanation for the delay, in fact, offered on the side or as on the part of the SIU to simply say, look, these are the reasons for the delay that made us, in fact, to take a period of over a year to come up with this review application under principle of legality. There hasn't been any application for condonation. We'll take you through that, Malady, and that affects the very same jurisdiction of this platform to hear the matter in the absence of an explanation in the form of a condonation. So, my lady, in essence, all we are saying is that, my lady, those issues needs to be determined first before one can say that we can hear the merits. So hence I'm suggesting that, my lady, if the issues of jurisdiction are at play at this particular juncture, then, my lady, hearing the merits of the matter, we are going to take you forth and back, in as far as the merits is concerned. One would argue that the merits, and then we'll come and say that we don't have jurisdiction. Then you have to pronounce on the issue of jurisdiction after hearing the merits of the matter. So, my lady, I was preventing such a situation, particularly in as far as the respondents are concerned. So, my lady, we are voting a question of going forth and back in as far as they are arguing the merits of the main application. Then we come and raise jurisdictional issues, and then you have to pronounce on jurisdictional issue, whereas you have had the benefit of the merits already. So, my lady, we were suggesting that in line with what I've just said, without repeating myself in that regard. Thank you, my lady.
Right, so we don't have the 5th and the 12th. Let's move on to the 6th respondent, Mr. Klopper.
My lady, in regarding to procedure, we're in your lady's hands, but I think the practicality of the issue is if there are points raised which goes to the core of the matter and which could have an effect dealing with the core of the matter to embark on a days of argument on the merits in those circumstances might be rather clumsy, if I may use that word. So I'm in your lady's hands in regard to that, but I think practicality and the practical approach must be reached to see how it is possible to deal with the issues in the without wasting or duplicating and wasting unnecessary.
Thank you. Seventh respondent. This one is Ramatsela or Mr. Satswana.
Yes, may I please record, my lady. I think I must just clarify one point, which I think is creating a bit of a confusion. I think what my lady called for was a submissions on whether or not my client's application for leave to file a further affidavit should be entertained first. The issue of jurisdiction and all other issues which are preliminary in nature are raised in that affidavit. The SIU has responded fully to the application for leave to file a further affidavit. They have also answered the contents of the supplementary answering affidavit which we seek to file. So if the previous colleagues are of the view that preliminary issues such as jurisdiction and the rest, and the Rule 53 point raised by Mr. Kela should be dealt with, that's a whole different issue. But as far as my client's application for leave to file a further affidavit is concerned, we don't think it should be dealt with separately. It ties in with all the issues that are raised in the application, and our view is that to separate it from the rest, and then we argue probably half a day, my lady then goes to consider it and come up with a judgment, we don't know when, then that may just make us lose at least part of the week if my lady is not going to give a judgment immediately. So we still submit that we deal with all these issues at once. Even the jurisdictional point, my lady, and the other preliminary issues, we submit that the correct way of dealing with it is to hear the entire case. My lady, if my lady finds that there is no jurisdiction, my lady will then give an appropriate order on it, instead of then my lady finding that there's jurisdiction and then we have to come back another day. You've already heard that we may not even be able to get dates in January, February, and March the following year, which is just going to be undesirable and wasteful of costs for the whole of this week. Those are our submissions, my lady.
Thank you. Then we're looking at there's no appearance 7th, 9th, 10th, Mr. Hardis.
Lady, we support what your lady put forward. I wish to just clarify two issues. My lady, the right to cancel the contracts or to declare them invalid is in dispute, as well as the disgorgement of the profit. They were both put down in this application. There's no distinction drawn between them, but there's a dispute in relation to both. but we agree that we should take advantage of this week to the extent that we can, my lady, and proceed either with the preliminary points first, or the merits, but that we grant condemnation for the late filing. There's no prejudice, everything is before the court, may proceed accordingly. Thank you, my lady.
Thank you. Then we look, and that obviously will go for the 13th respondent as well then. Mr. Hoders?
Yes, my lady.
All right.
Thank you, my lady.
Good. 11th respondent, Mr. Ellis?
Thank you, my lady. My lady, we align ourselves with the submissions of Mr. Tsatsawana and Mr. Hoders. We submit, my lady, that there is one elephant in the room in this case, and that is the factual disputes that relate to both the merits and the quantum. And we submit that if I can call them preliminary points that are raised by some of the respondents can be easily dealt with during the argument. If your ladyship finds ultimately that your ladyship has heard too much argument, then that would simply fall by the wayside. But we submit that it is in the interests of justice that a matter like this should be treated swiftly and be finished as soon as possible. Unlike some other respondents, the 11th respondent focuses on the merits of this matter, and we submit that the matter should be dealt with swiftly and that it shouldn't be dealt with piecemeal at all. Thank you.
Thank you. I think that's all the respondents. Do you have any reply, Mr. Arendse?
Thank you, my lady. My lady, no, just briefly, it just seems that the fourth respondent was also the one of the respondents who have filed their heads just now on the eve of this hearing, has certain objections to the approach, which I outlined at the outset, and which the remainder of my colleagues seem to align themselves to, my lady.
Thank you. All right, let's just deal with these things one by one. We'll start with the SIU's, the applicant's application for condemnation to file filing his replying affidavit late. There doesn't appear to be any opposition to that, and my view is that it was marginally late. It hasn't caused any prejudice that I know of or that have been articulated. So that application for condemnation is granted. Similarly, the condemnation by the sixth respondent for the filing of their affidavit is equally not opposed, and I don't see a problem with that. Having read the reasons, I'm satisfied that it will cause nobody any prejudice except the sixth respondent if it is not allowed. So the condemnation application there is granted for the filing of their supplementary affidavit. With regard to the fourth respondent, as I said, he is applied for condemnation, and I must express my absolute disdain for this kind of behavior. I'm appalled, and I must just say this in general, when I read the papers, and these are very extensive papers, at what I perceive to be a lack of respect for the rules of the tribunal, for the directives by the president, for just the conduct of matters in this tribunal. When one is faced with situations like this, it really is worrisome that people had months and weeks to file heads of argument, for instance, and it comes at literally the 11th hour. And of course, it's going to cause prejudice, not just to the other parties involved, but to this tribunal. It hamstrings, or I'm hamstrung, that I feel that I haven't yet given adequate attention to those heads, simply because there's a lot of other preparation to do. This is not the way that one conducts oneself. And with regard to that condemnation, I would not have been inclined to grant it, I must say so, but the applicant and the other respondents don't take issue with it, and I can appreciate to some extent that they just simply want to get on with the matter in the interest of time, and the impracticality of not using the time allocated for this matter this week. So, I'm very constrained, but I will grant that application, but I'm directing the fourth respondent to pay any costs that would have been occasioned by the late filing, and that's up to the other parties to indicate to the fourth respondent what costs they would have incurred. So any costs that have been incurred by the late filing of those heads and that condemnation application, the fourth respondent is to bear those costs. I think those are all the interlocutories. With regard to the seventh respondent's application to file the supplementary affidavit, I think the approach advocated by Advocate Setsawana as well as the other respondents is a salutary one, and it is the sort of matter where we can hear the whole, all the issues together, including the preliminary issues, as correctly pointed out by Mr. Ellis. And then we will deal with the rulings as and when they arise during the course of the judgment. And of course, the fact that we will deal with the merits doesn't necessarily preclude or prejudice anyone, even on the preliminary points such as jurisdiction. That can easily be dealt with in the arguments, and most definitely will be dealt with in the course of the judgment. So yes, I'm in agreement with the approach advocated by the majority of the respondents as well as the applicant. We can then continue with the arguments on the merits of the main application.
Valerie, before you one aspect, the 13th respondent was 1 day late as well, so it would also ordinarily have required condemnation. I assume that that's covered by your ladyship's judgment.
Yes, all the other evils that have been perpetrated are condoned in the interest of our carrying on.
As your ladyship pleases, thank you.
Good. All right. Do you want a short break before we start, or are you ready to start, Mr. Arnson?
Thank you, my lady. If this is a convenient time to take the usual tea adjournment.
Yes.
And we can, shall we start in 15 minutes?
Yeah, so 15, 20 minutes should be fine. Let's make it 20 past 11. All right, we'll resume in 20 minutes.
Thank you, my lady. Thank you, my lady.
Thank you.
Thank you, my lady.
I think we're back on. Is everybody back? You're back.
Thank you, my lady.
Is everybody rejoined now?
We are back, my lady.
Okay.
Yes, my lady.
All right, then, if everybody is on board, then we can continue.
Thank you, my lady. My lady, as proposed at the outset, we wish to unpack the issues in dispute in the following way: to deal first with the action versus motion point, which have been raised by all the respondents. Then deal with the delay point, which is raised by 6, 11, and 13. Then deal with the hearsay, again, aspect of Mr. Du Toit's affidavit, which is raised by 6, 7, 10, 11, and 13. The non-joinder point raised by all the respondents. Then deal with the setting aside of the contracts. That's paragraphs 1 to 4. That's the declaratory relief which we seek. And then lastly, deal with the just and equitable aspect of the case, which is paragraph 7 of the relief that we seek. But my lady, just before we do that, if I may just refer to what we have gleaned from all the papers are facts and or state of affairs which are not.
Sorry, my lady. I'm sorry to interject. Advocate Douglas has his hands up. I'm not sure if he needs to say something.
Sorry, I can't hear you. Is that in Paul?
Yes, my lady. I was saying
you said what?
Kale had his hand up. Advocate Kale had his hand up.
Oh, I see.
I'm not sure if he wanted
Mr. Keller?
to say something.
Thank you, my lady. Apologies, my lady. I can deal with the issue later on. I tried to raise it earlier on, but I could not. But at this stage, I will raise it later on, my lady. It's fine. Thank you.
Okay.
Thank you.
Thank you. All right. Thank you. You may proceed, Mr. Arendse.
Thank you. My lady, just before I proceed to unpack or to deal with those separate issues, just to refer to what we refer to as the uncontroverted facts, or the common cause facts raised by the SIU in its founding affidavit, and which are not contested or disputed by any of the respondents. So the context, my lady, of this matter is the COVID-19 pandemic. There was an inspection of the hospital, West Rand Hospital, then owned by the first respondent and subsequently by the second respondent in and during March. There was an inspection, and there was then a need expressed by the Department of Health to utilize the facility for the purposes of the COVID-19 patients who may need care, and there was quite desperate need at the time. So that's the context, my lady. So
yes, I think that the background has been set out extensively by the applicant, as well as it's been added to by the other respondents. And I think we must try to simply and of course the heads and papers are very extensive and cover all those aspects quite well, I think. I think what we need to do with the argument, because there's so many respondents and so many counsel who will be arguing, is to try and keep the arguments as crisp as possible. Whatever's not in the heads that you wish to draw to the court's attention, or in your case now you say you want to go to the common cause facts, which is important because there's so many different respondents, and you're going to simply pull the threads to bring them together to say what the common cause facts are. Background and so on, it's not necessary. So, you know, I've got a pretty good idea of what that is.
As your ladyship pleases, I think the only reason why we raise it is to emphasize this point, my lady, in relation to the relief that we seek, that the contracts and awards be set aside, is that despite the very unique circumstances we were in, the emergency circumstances that we were in, our constitution was not suspended. The laws that inform procurement were not suspended. They remained very much in place. And for that reason, it was important for all the parties in the case, the 15th and 16th respondents in particular, to conform to the procurement protocols prescribed in the law and which is contained in the Constitution at section 217. In other words, that any process of procurement must be fair, transparent, equitable, competitive, and cost-effective. All those hallmarks, my lady, were absent in this case. We know, your ladyship knows, that the lease agreements were entered into between GDID and the first and second respondents, and those lease agreements expired in January of 2022. Now, importantly, my lady, on the 19th of March 2020, the health department approached GDID for the refurbishment of the hospital at a cost of 50 million rand. This was to create some between 200 and 250 beds that would be occupied during that period. On the 24th of March, in an internal GDID communication, they requested for the approval for the appointment of PSPs and contractors on an emergency basis. The budget that was specified, my lady, was for 50 million rand for a 30-bed hospital. Okay. The fourth respondent was listed on the panel to provide construction project management for mechanical engineering works only, and is not a quantity surveying firm. Only the 11th respondent was at the time listed on GDID's contractors panel. None of the other contractors. On the 25th of March 2020, the first appointment letters were issued by Mr. Tabani of GDID.
Just give me a minute.
On the 25th of March, the first appointment letters were issued by Mr. Tabani of GDID. And importantly, my lady, no scope of works or contract price is included in those in that first batch of appointment letters, and there's no completion date. So effectively a blank check. The appointments were made subject only to the finalization of an agreement to acquire the hospital. Of course, they were all accepted, these appointment letters, notwithstanding the missing information. On the 31st of March, Treasury, 17th respondent, requested from the Department of Health, the 15th respondent, its funding requirements, but they recommended, Treasury recommended against proceeding with the hospital, with the acquisition of the hospital. Subsequently, on the 3rd of April 2020, virtually identical appointment letters were sent to the contractors and the PSPs. Again, all were accepted. On the 16th of April 2020, site access letters were issued to contractors, and the completion date was now stipulated as 30 May 2020. The contractors entered the site and commenced setting up setting up at the site camp and commenced working even before the scope of works was identified. So crucially, my lady, what was initially supposed to have taken 6 weeks to complete, the first part of the works were only handed over in May 2021, almost a year to the day. Written service level agreements were entered into either in May or in June 2020, but only after the works had commenced. But the agreement remained incomplete, and this is apparent from some of the documentation that the respondents, some of them attached to their papers. And as far as the PSPs are concerned, only a percentage for fees was specified, but no contract amount was stipulated. The bill of quantities itself was only approved in June 2020. And we mentioned here that in the memorandum supporting it, some misleading statements were made by one of the officials. On May 2020, Treasury informed the Health Department, as early as May, my lady, on the 8th, Treasury informed the Health Department that costs on the projects had far been exceeded, at that stage estimated to be 250 million rand. And there were delays in the project in relation to ownership and procurement documents being requested. On the 29th of May 2020, GDID reported a deviation to Treasury. On the 10th of June, a third version of the appointment letters was issued, this time setting out a contract price.
Just a minute.
Was sent to the contractors and to the PSPs. Between April 2020 and April 2021, the contractors and the PSPs had been paid in excess of 500 million rand.
Just a minute. Mm-hmm.
So just in essence, my lady, a contract initially contemplated or envisaged to cost 50 million rand had grown quite exponentially to 10 times more than that, to over 500 million. What we know as a result of all of this, my lady, is that and it's very sad, and we submit the respondents who were engaged to do some of the work on the project. Someone must be held accountable for this. Health no longer occupies the hospital. In fact, they have no right to do so, and the hospital was never, ever fully completed. The accounting authority of the Department of Health was only made aware of the ultimate costs once works were already well underway. We submit a manifest breach of Section 38(1)(a) of the PFMA. What is common cause, my lady, and not in dispute, is that there were no price quotations or negotiations with any of the respondents, the contractors or PSPs, which we submit again is fundamentally in breach of GDID's own policy. There was no pre-approval for expanding or varying the contract. From the original cost. It is not in dispute, my lady, that the lease itself was procured in a manner that was inconsistent with the procurement regulations, as there was no feasibility study or business case for the project, which is otherwise a requirement, my lady, for an unsolicited proposal. So, my lady, those are we submit are facts that your ladyship will find in this matter, and which foreshadows any debate that we will have in relation to some aspects that are raised by some or all of the respondents. If I may turn to the first disputed aspect, which is that we should have brought this application by way of action, and not in the way that we have. Despite, my lady, your ladyship will be aware of several matters that have been heard in this tribunal where this exact approach has been followed. In fact, my lady, if I may just refer to the case management minutes. Now, my lady, the case management minutes are at 77, my lady, 077.
Mm-hmm.
The more recent one is the one at 15 June 2022, 077-10.
Mm-hmm.
Now, your ladyship has already expressed your ladyship's displeasure at some of the timelines that had been directed by the court not having been followed and so on. The reason why I refer to this minute, my lady, is that the framework for this case that we have followed and which the parties have been directed to conform to is laid down in this case management minute. There is, in fact, a minute which is not loaded to case lines, my lady, which is on the 13th of February, where Her Ladyship Modiba had in fact proposed this very route that the SIU has taken in this case. We have referred to it in our replying affidavit. If I may just find the okay. It's at 100 and it's at page page 18. 18. But is it 100-18? It's at 100-18, my lady.
Mm-hmm.
And I'm reading from paragraph 13. However, during the initial case management meeting held virtually on 11 February 2022, objections were made on the part of certain of the respondents, including some of the respondents who now challenge the SIU's amended course of conduct, to the SIU not making use of the provisions of Uniform Rule 53, and to pursuing it the just and equitable relief on a piecemeal basis by way of a bifurcated procedure. They further objected to the absence of a final expert report. During the aforesaid case management meeting, the learned Judge President Modiba indicated that she was not inclined to consider the question of just and equitable relief separately, and that while the quantum thereof may be a different question, she suggested that the applicant take advice and consider incorporating its evidence and the relief sought as to just and equitable relief into its application. She further agreed with the respondent's complaints regarding the absence of a final expert report and accordingly directed the following dates for the exchange of papers. Those respondents who were desirous of delivering a notice in terms of Rule 3512, requesting certain documents referred to in the filing affidavit to do so by the 15th of February. The applicant would reply to it by the 8th of March. The applicant would file its supplementary filing affidavit by 5 April, and the respondents filed on the 24th of May. Of course, those dates, my lady, were subsequently revised. And then at paragraph 16, my lady, which is at 100-19, paragraph 16, I point out that the vast majority of the 3512 requests received...
So you're reading from your replying affidavit now, right?
Yes, my lady. Paragraph 16 on page 100-19.
Yes.
I point out that the vast majority of the 3512 requests received from the respondent were to access documents already uploaded to case lines, but which they had chosen not to consider. The SIU nevertheless responded thereto, providing each of the respondents who made such requests with page references to the documents sought or with copies of other documents sought where applicable. Under great time pressure and without access to all the documents, as paragraph 17, as you would have liked, the SIU's expert further prepared an expert report within the timeframes ordered by the tribunal, and the SIU delivered its supplementary affidavit incorporating that report commensurately. So, my lady, the procedure that was followed and that was adopted was a procedure that had been raised by some of the respondents, addressed by the judge president, and was subsequently followed by the SIU, and that is what is outlined in our notice of motion, and the amended notice of motion, which was filed on the 5th of April of this year. My lady, we deal with this aspect of the case, the action versus motion, in our heads of argument. From page 2 at 054-219 to 223.
Yes.
Yeah, I'm just scrolling to find it. Just while I scroll to find that reference.
Sorry, are you talking about your heads?
Yeah, I'm going to find the reference in my heads now. But if I may just foreshadow what I'm going to say next, with also what's happened was that the only respondent, after all that hullabaloo and complaints about an expert report, only the 10th respondent filed a comprehensive expert report of their own, and the 11th respondent also filed some kind of expert report. None of the others respondents have filed any expert reports. They confine themselves, my lady, to some bold denials, which we submit must be rejected. So it's only the 10th and 11th respondents that have filed, and comprehensive answers your ladyship will find in our replying affidavits, in our replying affidavit. So, my lady, just to go to our heads at 054219, we deal with action proceedings that is asserted to have been followed. We start at paragraph 114, where we say that review relief is required to be brought by way of application, and ordinarily litigants are not penalized by bringing matters which involve disputes of fact by way of application when that is the required procedure. And of course, disputes of fact, if they are not genuine or bona fide or frivolous, then the court will exercise its discretion to dismiss them. And to the extent that a bona fide dispute of fact is raised, the normal way of dealing with them is to apply the Plascon-Evans rule. But we submit that where review relief has been brought in the way and manner that we have, and as directed by the Judge President, and which has been the way matters of this nature has been brought by the SIU in this tribunal, that there was nothing wrong, irregular, or untoward in pursuing this route. To a large extent, my lady, the disputes raised, as I pointed out, it is only the 10th and 11th respondents that have attempted to seriously challenge Ms. Mutara's report. None of the other respondents do. So to that extent, any disputes that they've raised are based on bold denials and should be summarily dismissed. So we submit at paragraph 115 of our heads, which is still at 54-219, that on the facts of this matter, your ladyship is required to consider firstly the judgment that was handed down in the interlocutory or proceedings dated the 21st of January 2022, when the preservation application was made and granted. That involves the 5th and 6th respondents.
It's the 6th and the 13th.
6 and 13, thank you, my lady. And then the notice of motion dated the 13th of December, and paragraphs 36 to 38 and 100 of the founding affidavit. The events that I've referred to already that transpired at the case management meeting of 11 February, and then the contents of the amended notice of motion, Ms. Mutara's report of 8 March 2022, and the supplementary founding affidavit which was deposed to on the 5th of April 2022, to put the relief sought in its proper context. Then we submitted at 116 that while disputes of fact were envisaged in this matter, in particular relative to the just and equitable portion of the relief sought, once the SIU was in possession of Ms. Mutara's final report, it had all the information on overcharging to hand that we were going to be able to ascertain in the time periods available, and as a result, then sought to amend the relief sought to a just and equitable claim in the proceedings. This approach, as I've mentioned, took into consideration the objections made by some of the respondents' legal representatives to the initial bifurcated procedure proposed, the learned Judge President's comments and surrounding the just and equitable relief and overcharging. Paragraph 117 makes reference to the 10th respondent filing, with the only party being filing a full expert opinion to meaningfully dispute Ms. Mutara's report as to the amount of overcharging on the project, and the 11th respondent who filed a preliminary expert report. Accordingly, we submit, save for one specific complaint made by the 13th respondent to an item on the bill of quantities, which Mr. Swoboda has revised, your ladyship is left with nothing other than vague and generalized statements made by the opposing respondents themselves that they did not overcharge on the project. We submit that this is particularly egregious, as the respondents would necessarily they would obviously have all the necessary documentation, drawings, receipts, measurements, invoices, and the like, to determine that is required to determine whether or not they overcharge. But they've elected, my lady, not to make this information available to this court, or to take the court into confidence by making it available, in order to create what would otherwise be a genuine dispute of fact. And we submit, my lady, on the ordinary principles of the law of evidence. If you make an allegation supported by documentation which is not disputed, seriously disputed, or attacking or challenging the authenticity of these documents, then the allegations must stand as facts. So we submit, my lady, at 118 that the answering affidavits do not amount to the type of dispute which is either required to be determined on the Plascon-Evans basis, or that should be referred to oral evidence or to trial. We submit that the SIU has discharged the evidentiary burden to show overcharging on the part of the respondents on a balance of probabilities. My lady, on our part, Ms. Mutara and Mr. Detoy, on the basis of evidence and information collected, has tried to explain why a project that was initially estimated to cost 50 million to the taxpayer ended up costing in excess of 500 million. There was the evidentiary burden shifted, as it would in a trial, to the respondents to explain how and on what basis the project grew to this massive amount of money. We submit, my lady, that if your ladyship disagrees with our submissions and believes that it cannot resolve the disputes of fact pertaining to overcharging, then it is submitted that that your ladyship need not make orders in respect of overcharging specified in our notice of motion at paragraph 5. And that is why we submitted, my lady, at the outset that the aspect of the disgorgement of profits be dealt with at a later stage. In the event that your ladyship sets aside these contracts as invalid, unlawful, and or unconstitutional. We refer your ladyship to paragraph 10 of Mr. Du Toit's supplementary finding affidavit, where he stated, and I quote, "In the event the special tribunal does not accept the basis and extent of overcharging set in the Matara consulting report, the SIU an order allowing for a statement and debatement by the 3rd to 14th respondents, in terms of which they will be required to account for and to repay the SIU or the 15th and or 16th respondent all their profits made from works performed and or goods and services delivered or rendered to the hospital project in an amount either to be agreed or further determined by this tribunal." This is now the primary relief sought by the SIU. And if this process is followed, then the respondents are ordered to disgorge their profits, and the actual quantum of the overcharging is not necessary to be determined. And in this way, my lady, the respondents cannot be heard to complain of any prejudice, as they will have the opportunity to present the actual proof of their costs and expenses incurred in relation to the project. So, my lady, that is in relation to the first aspect of the case. If I may just, if it's helpful, refer your ladyship to the heads of argument of some of the respondents where they deal with this, and I'm obviously not going to deal with it now. The third respondent, my lady, all the heads are at 054. The third respondent at 353 to 357. The 10th respondent at 328 to 336. The 11th respondent, 459 to 461. The 13th respondent makes the same submission as the third. Mr. Otis represents also the third.
Surely the 10th. 13th. Wasn't the 13th?
The 10th, yes.
The 10th, yes.
Yeah. Thank you, my lady.
Before you move on to the next point, I'm not sure if you're going to deal with this, but are you going to say anything about the 2 expert reports filed by the 10th and the 11th respondents at this point?
No, not at this point, my lady.
Okay.
We'll deal with it.
Yes,
my lady, just in relation, just to round off the disputes of fact point. there is reference to the case of Whiteman trading as JW Construction versus Headfall. It's 2008 brackets 3 SA 371. It's an SCA case at paragraph 13. And we submit this. This is the approach your ladyship will also follow. If I may just quote from it. When the facts averred are such that the disputing party must necessarily possess knowledge of them and be able to provide an answer or countervailing evidence if they be not true or accurate, but instead of doing so, rests his case on a bare or ambiguous denial, the court will generally have difficulty in finding that the test is satisfied. I say generally because factual averments seldom stand apart from a broader matrix of circumstances, all of which needs to be borne in mind when arriving at a decision. A litigant may not necessarily recognize or understand the nuances of a bare or general denial as against a real attempt to grapple with all relevant factual allegations made by the other party. But when he signs his answering affidavit, he or she commits himself to its contents, inadequate as they may be, and will only in exceptional circumstances be permitted to disavow them. There is thus a serious duty imposed on a legal advisor who settles an answering affidavit to ascertain and engage with facts which his client disputes and to reflect such dispute fully and accurately in the answering affidavit. If that does not happen, it should come as no surprise that the court takes a robust view of the matter. So that, in support, my lady, of an earlier point which I made about the approach by virtually all the respondents to this matter. The answers are laced with bare denials. So we submit, my lady, it doesn't assist the respondents generally. That they are and were party to the knowledge of the costs and expenses and ultimate charges. And yeah, I address myself in particular to the third respondent that it had knowledge of the expenses and ultimate charges for work done at the hospital, and they ought to have been in a position to dispute Ms. Matara's conclusions that they were not reasonable. The third respondent put up no evidence as to its costs, charges on other projects, market-related rates, etc., to demonstrate that it did not overcharge, but contented itself with a bare denial. So in relation to the third respondent in particular, my lady, we submit that no material dispute of fact arises. I now will just focus on some.
In any event, the third respondent is not opposing your declaratory relief.
That's correct. I think it abides the.
Well, what he says, they say is that they can't really dispute it.
Yeah. Thank you. My lady, may I just ask for a few minutes comfort break, my lady?
Yes, certainly.
Just a few
10 minutes?
Just 5 minutes, my lady.
Okay. Okay, we'll take a short adjournment.
Thank you.
Mr. Arendse?
Thank you very much, my lady. I'm just referring to some of the individual respondents and their view on this topic of action versus motion. I've made the remarks in relation to the third respondent. The 10th respondent, my lady, they refer your ladyship to the matter of SIU versus Zilwa. Now that judgment, Zilwa, ZEELWA, that judgment was handed down on the 13th of October, which was after our heads were filed. And they say that the SIU knew that it ought to have proceeded by way of action, and that the SIU cannot, as they put it, rely on the moral high ground to do as it wishes in this tribunal. They also referred to another decision, which is an unreported constitutional court decision of Mamadi, M-A-A-D-I, and another versus the Premier of Limpopo Province, a decision of the 6th of July, to say that litigants should apply for a referral to oral evidence or as soon as affidavits have been exchanged. In this regard, my lady, your ladyship would have seen that the SIU did subsequently, particularly in relation to the second aspect of the case, ask for an alternative order of a referral to oral evidence if this is deemed appropriate by this court. We've also asked for an alternative in the form of a statement and debatement procedure. My lady, we, just in terms of the approach we've adopted, we wish to refer to this case, which is not in our heads of argument, because it's dated 7 November 2022. It's in the SCA Greater Zanin Municipality versus Bravo Span.
Versus?
Bravo Span, BRAVOSPAN. The case number is 428/2021 ZASCA at 155, where the court said at paragraph 21, and I quote, ordinarily, a declaration of unconstitutionality and a just and equitable remedy would be claimed in the same proceedings. But I can see no reason in principle why relief under section 1721A and 1721B, that's of the Constitution, may not be claimed in separate consecutive legal proceedings. One can, for example, envisage a case where a declaration of unconstitutionality may be obtained on motion because of the absence of factual disputes in respect thereof, but where the nature of the disputes in respect of remedy would require their determination at a trial. Then it says here, counsel for the municipality conceded that all the facts relevant to whether Bravo Span should in principle be compensated under 1721B are before us, and that the municipality would not be prejudiced by an order referring the matter back to the court or quo for the determination of the quantum of just and equitable compensation. And that has been our approach, my lady, from the outset. Just a note on some of the other respondents on the the 11th respondent. They say that they only intend to raise this if it is found that the SIU put up credible evidence, but their view is the same as Yukusasa's approach, which is, their view is that their evidence, that's Yukusasa's evidence, and that of the expert creates an irresoluble dispute of fact, which results in action proceedings that has to be pursued. And for that reason, the application ought to be dismissed. Then the 13th respondent doesn't seriously engage us on this issue. Yeah, it's the same as the 10th respondent. Then, my lady, if I may move to the next topic, which is delay. Our heads of argument at 229 to 231 at paragraph 139, my lady, of our heads. At paragraph 139, we say that the 6th and 13th respondents have alleged that this review is time-barred as it was not brought within a reasonable time. This is denied by the SIU. Mr. Du Toit's investigation was completed by the 12th of August 2021. The interlocutory ex parte proceedings for the preservation order was launched in September 2021. And as your ladyship will know, the standard procedure was then followed, that the review had to be launched within 60 days of those initial proceedings, which would have been in December 2021, and that's what happened in this case. So we submit that this was a period of just over 4 months, which in the circumstances is reasonable. And the review proceedings was launched in accordance with a court directive. The challenges, however, made by some of the respondents appear to be that the SIU and GDOH Health and GDID knew in November 2020 already that the procurement process appeared to be non-compliant with Section 217 of the Constitution, and that any further payments may amount to irregular expenditure for purposes of the PFMA, and that there had been an extreme price escalation. This is premised on a letter sent by the head of the SIU, Mr. Advocate Motibi, on 25 November 2020, in which he recommended that GDOH cease making further payments to the respondents owing to the SIU's investigation, which was said to be underway and in respect of which the SIU had or would be briefing council to bring a review. But we submit, my lady, self-evidently, the SIU could not pursue the review immediately or even shortly thereafter, because it had to ascertain all the relevant facts. It had to be investigated. And as we know, Mr. Du Toit's investigation was only completed in August 2021. And we submit, my lady, that the process did take some months, but was hamstrung, not surprisingly, by a inter alia lack of cooperation on the part of the provincial departments and some of the respondents that had to be interviewed by Mr. Du Toit. Of course, as to why GDOH and GDID did not pursue their own review applications themselves, the SIU cannot answer for them, my lady. We endorse the words of the Constitutional Court in Buffalo City Metropolitan Municipality. This is at paragraph 142 of our heads, my lady. Buffalo City Metropolitan Municipality versus Asla Construction. It's a 2019 4331 Constitutional Court case, where in the context of a municipality having embarked upon an unlawful procurement process, the court said at paragraph 41 of the judgment, the municipality ought to have become aware much sooner than it did, even prior to and without the benefit of an independent investigation, that its employees are awarded the recent contract without going through a procurement process. Municipalities must have effective structures and mechanisms in place to ensure proper oversight for its service delivery projects. This is one of its core responsibilities. It must detect and prevent the abuse of taxpayers' money. A lack of effective oversight leads to dysfunctionality within municipalities by creating loopholes for fraud and corruption. We refer to that case, my lady, because the same can be said of the provincial departments in this matter. But in this case, the review is partly brought on their behalf, but mainly by the SIU itself. The provincial departments are not cited, are cited as respondents and not as co-applicants. So failure to bring any review proceedings sooner can't be visited or foisted on the applicant, which has proceeded within a reasonable time of ascertaining all the relevant information and facts. And we submit that it is in the interest of justice that the review be determined owing to the enormous amounts of expenditure of state funds involved in this case and the extent of the irregularities. Then, my lady, the third topic is hearsay, which we deal with at 054-156. And just while I scroll to find it on case lines, I mentioned at the outset, my lady, that there's no attempt by any of the respondents to indicate where and in which or what aspects or respects of Mr. Du Toit's affidavit hearsay, the evidence is hearsay. 6.
While you're scrolling, I have read the heads, as I say. It just refer me to which part of your heads that you're referring to. Because as I said, I've read it, and it's just a question of my going back to the paragraph that you now refer to. Just in the interest of time, you know, I've got a number of...
Yes, my lady. Yeah. This aspect of the case, my lady, is at 054-156, beginning at paragraph 10, under the subheading, the mandate of the SIU and Mr. Du Toit's personal knowledge.
It's not necessary to read all of it. Just give me the gist of it, and then it's fine.
Yeah. My lady, this was an investigation that was initiated by the SIU. So Mr. Du Toit goes in to the relevant departments and speaks to the relevant officials and collects and collates a whole number of documents relevant to the contracts, the award of the contracts, and so on. But his investigation is also required to take into account what the respondents have to say. So in this matter, your ladyship will see, and it's not contested, that Mr. Du Toit does attempt to interview some of the respondents. But the attitude is either one of great reluctance or refusal to engage with him on the investigation. And we submit, my lady, this is tantamount to a witness giving evidence in a tribunal like this, or in a court of law, or in any adjudicatory chamber, and was not being cross-examined, and certainly not being cross-examined on the basis of a contrary version or contrary facts. And so when Mr. Du Toit deposes to his affidavit, he has conducted himself fairly. He has given the respondents an opportunity to respond, and it's not forthcoming. So, for example, at paragraph 16 of our heads, we say there was a complete absence of a tender process. There was nothing forthcoming from any of the respondents to gainsay that. At paragraph 17, that's the reference, my lady, during Mr. Du Toit's investigation, which took place between March 2021 and mid-August 2021. He conducted interviews with the relevant role players, sent emails and telephonic requests for information, conducted site visits, and had meetings with various
So
parties.
you keep the thing keeps freezing. I didn't get the last bit. You said
Paragraph 17, my lady. Just to emphasize, paragraph 17 of our heads. This is what I mentioned. Mr. Du Toit's investigation took place between March 2021 and mid-August 2021. He conducted interviews with the relevant role players, sent emails and telephonic requests for information, conducted site visits, and had meetings with various parties, including several of the respondents, to obtain as much information as possible regarding the procurement surrounding the hospital. And this is evidenced by the factual contents of his investigative affidavit. He obtained thousands of pages of documents. And make the right point, my lady, these documents have all been admitted, not challenged at all by any of the parties. So their authenticity is not in dispute, my lady. So if it's not disputed, it becomes hard fact, my lady. It's no longer hearsay evidence. We mentioned, my lady, in our heads that the admission of hearsay evidence is governed by the provision of the Law of Evidence Act, Section 3(1)(c). I'm not going to read that out, my lady, and we submit that.
It's really not necessary. As I said, just refer me to the paragraphs. I have read these heads. I've spent many hours reading the heads, so you simply have to refer to the paragraphs that you want me to look at.
Yeah, to the extent necessary, my lady, in order for us to move that hearsay evidence be admitted by the court, we rely on Section 3(1)(c) of the Law of Evidence Amendment Act. It's set out in paragraph 19, and having regard to those factors, we submit that the evidence of Mr. Du Toit's, Mr. Du Toit's evidence be admitted in its entirety. And the reasons that we give, my lady, is at paragraph 20.1, the nature of the proceedings. 20.2, the nature of the evidence is mostly documentary in nature. It was obtained directly by Mr. Du Toit from officials in the departments. The purpose for which that evidence was tendered was to demonstrate an absence of a procurement process having been followed. His evidence is of high probative value. 20.4, 20.5. This is perhaps important. The reason why none of the state officials, this also ties in with the joinder point, my lady. The reason why none of the state officials, save for Mr. Nkomo and Mr. Koloshle, have deposed to confirmatory affidavits is owing to their resignations, suspensions, and or pending disciplinary proceedings. Insofar as the disciplinary proceedings themselves are concerned, which are ongoing, these were convened at the instance of the SIU and form part of its recommendations. Mr. Tabani, who was the one who issued these appointment letters on 3 occasions, for example, declined to provide a statement to Mr. Du Toit. We submit that these are compelling reasons why state officials have not themselves confirmed Mr. du Toit's allegations. As regards the final ground, we submit on the broad any other factor, we submit that there are compelling reasons why his evidence should be admitted, for the simple reason that none of the respondents legitimately contend that any tender procedures were followed. They were all, my lady, appointed pursuant to a telephone call and admit having accepted their appointment and commencing prior to the scope of works and contract price being agreed. And we also wish to refer your ladyship to section 9(3) of the Governing Act. A special tribunal may, and I'm reading from paragraph 20 of your heads, my lady, last paragraph. A special tribunal may, in consultation with the parties appearing before it, take any steps in relation to the hearing of a matter before it which may lead to the expeditious and cost-saving disposal of the matter, including the abandonment of the application of any rule of evidence. And lastly, my lady, we submit that his evidence be admitted because it's in the interest of justice to do so. We refer to this tribunal in Special Investigation Unit versus the National Minister in the Department of Public Works, and another at paragraphs 82 and 83, accepted the hearsay evidence of the SIU's investigator, Mr. Grubb, in a similar founding affidavit, deposed on the basis of findings and investigations and findings supported by relevant documentary evidence. My lady, to the extent that there is a reliance by the 11th respondent on is it SIU versus engineered systems? Yeah. SIU versus engineered system solutions. It is a recent SCA case.
Which paragraph of their heads?
My lady, this is not in the heads, my lady. This is, of course, you know, the 11th respondents' heads were filed after ours. 2022 brackets 5 SA 416 SCA at paragraphs 40 and 41.
What's the name of the respondent there?
Engineered Systems Solutions.
Okay, thank you.
In that case, and no doubt the 11th respondent, when they address your ladyship, will place more emphasis on it. But just on our reading of it, we submit the case as distinguishable. In that case, there were no the departments concerned were co-applicants, unlike in this case, my lady, where they are cited as respondents. They were co-applicants, and notwithstanding that, there were no supporting or confirmatory affidavits filed together with Mr. Du Toit's affidavit. And in that case, the SCA found that his evidence was constituted hearsay evidence. But in this case, my lady, there are two important supporting and confirmatory affidavits which Mr. Du Toit does refer to. And if I may just ask your ladyship to also note that it is at 78 78 078-78. There's a reference to the affidavit of Mr. Nkomo. And then Mr. Nkomo's own confirmatory is at 078-406-409. So if I may just yeah. Um, 78. At 78 or 78 at at paragraph 130, Mr. Du Toit says, after dealing with the appointments of the PSPs and the contractors, he says that the aforesaid is, I respectfully submit, readily apparent from the facts set out above, but is also confirmed by Mr. Nkomo of Gauteng Treasury Director Infrastructure Performance by way of his confirmatory affidavit, which is attached, marked FA 28. Now, at FA 28,
it's not necessary to read the affidavit of Mr. Nkomo. Yeah, really,
please,
move on.
Yeah, and then Mr. Koloi's affidavit, QOLOHE, his affidavit is at 78-463 to 465, and he is from the Gauteng Department of Health. Then in relation to the individual affidavits, my lady, if you could please just make a note of the responses of some of the respondents on the record. The third respondent doesn't deal with this aspect at all. Their answer is at 092. The fourth respondent, 093-44, paragraph 106. Just a bare denial. The seventh respondent doesn't deal with it at all. The 10th respondent at 094-47, paragraph 139. They rather take the joinder point, which I'm still going to deal with.
Paragraph, what paragraph? 47?
Paragraph 139, 094-47, paragraph 139. They complain about Mr. Tabani not having been joined. The 13th respondent, 096-42, at paragraph 140. The sixth respondent at 097 at paragraph 1-5, paragraph 157. They say that Mr. Nkomo didn't read Mr. Du Toit's affidavit. I don't know how they arrive at that conclusion or draw that inference. The 11th respondent, they don't deal with it at all. Yeah. So, my lady, that concludes the submissions on hearsay. And perhaps after the lunch adjournment, my lady, I could move on to the next topic, which is non-joinder. It shouldn't take long.
Yes, as I said, I have read all the heads. I'm familiar with them. All I need is just a reference to a particular point in the affidavit and why you're making, or a particular paragraph and why you're making the point. That's basically it.
Thank you,
and I hope that the other respondents, because in the interest of time, we've got many of you that need to address, and we're going to run seriously out of time if we don't manage the time properly. Okay.
As you please, my lady.
All right, we'll take the lunch adjournment now and we'll resume at 2. Is that all right?
Yes, my lady.
Good. Okay, we'll adjourn. Thank you. Right, good afternoon again. Is everybody on board?
Yes, my lady.
Mr. Arendse, are you with us?
We are here, my lady.
Oh, good. Right, Mr. Arendse, if you're ready, you can continue.
Thank you, my lady. We deal now with the non-joinder point. Our heads 054, 223 to 225. We'll just look at some of, respond to some of the individual respondents to the extent that they have dealt with it in their heads of argument. The heads of argument we had an opportunity to look at. We just note that from some of the late heads that were filed, the 11th respondent, they say if we had proceeded by way of action, they could have subpoenaed witnesses. We don't see any reason as a matter of procedural law, my lady, why in an opposed motion, in an application, why you cannot approach what would otherwise be the other party's witnesses to depose to an affidavit. I don't even think you need permission necessarily. So that doesn't preclude you from doing so. The 7th respondent, they mention nothing in their heads, and neither does the 4th respondent. The 3rd respondent in their heads of argument, they don't expand on this point at all, and they don't cite any any case law in support of the submission that the decision makers must be joined. And in response, my lady, we submit this reference as decisive of the matter. There is a recent SCA judgment, which I think I may have referred to earlier today already. Siangena it's not in our heads of argument, my lady.
Yes, you did say so.
Yeah, Siangena Technology versus Prausa.
Citation?
It is square brackets 2022, close square brackets ZASCA 149 brackets 1 November 2022.
Okay.
So it's available on SAFLI, my lady.
Okay.
In that case, the court held in response to a contention made that officials of state-owned entities implicated in wrongdoing ought to be joined in the proceedings to allow them to respond to allegations made against them. as follows at paragraph 25, and I quote, "There is certainly no provision in the Uniform Rules of Court for the intervention of a witness in an application in any event. PRASA was not seeking relief against any of those identified as witnesses. The relief sought by PRASA was confined to the setting aside of the JBCC agreements, the contracts concluded with Siangena, and orders setting aside the arbitration agreements. None of those quote-unquote intervening witnesses had any direct and substantial interest in the relief sought by PRASA." Just two things on that judgment, my lady. One, no allegations of wrongdoing is made against any of GDOH or GDID departmental officials. One or two of them are mentioned in the affidavits, Mr. Tapani, and as a matter of fact, that's not disputed, that he issued the appointment letters, for example, or made telephone calls to the parties to appoint them. Yes, it may have subsequently become the subject of disciplinary inquiries, but at the end of the day, given the test, my lady, and we submit your ladyship will be guided by the where's that case? The necessity to join a party, my lady. The leading authority would say, it is referred to in the heads of argument. A JSC, sorry, it's not. JSC versus Cape Bar Council, 2013 (1 SA 170 SCA, where the SCA said the following regarding...
Sorry, Mr. Arunsa, you said 2013 1.
2013 (1).
Okay, good.
SA 170.
I was actually surprised I didn't see it in your heads.
There you go, my lady. Well, now we mentioned it. I also thought it was there, but it clearly wasn't there. And,
you froze up again there for a minute. I didn't. Did you say anything in the last few seconds?
I just said that it wasn't there, and I thought it was there, but I take responsibility for not putting it in your heads of argument.
That deals with direct and substantial interest, right?
Yes. So this is this is what it said in that matter. It has by now become settled law that the joinder of a party is only required as a matter of necessity, as opposed to a matter of convenience, if that party has a direct and substantial interest which may be affected prejudicially by the judgment of the court in the proceedings concerned. And there's a reference to a previous SCA case of Bowring, a 2007 case. There were facts that a party may have an interest in the outcome of the litigation does not warrant. If there were facts that a party may have an interest in the outcome of the litigation, does not warrant a non-joinder plea. The right of a party to validly raise the objection that the other party should have been joined to the proceedings has thus been held to be a limited one. And there's a reference to a previous SCA case in 2007, Berger versus Rand Water Board, and then to some of our writers, Cheryl Lutz and Epstein and Van Vincent civil practice, and the cases they cited. The 10th respondent. So just in summary, we submit that none of the officials as I said, perhaps one or two of them are mentioned in Mr. du Toit's affidavits. None of them have a direct and substantial interest in this litigation. And to the extent that they are witnesses, it's clearly not necessary for them to be joined. And there was nothing stopping any one of our colleagues or the respondents from contacting Mr. Tabani or any other official involved in this whole process from deposing to an affidavit on their behalf. But we can only suspect why they didn't exercise such an option. May not have been favorable. As far as the 10th respondent is concerned, they assert in paragraph 51 of their heads the following. Which we find quite astonishing. And I quote, "The disputes of fact are not limited to the alleged just and equitable relief sought, but also go to the heart of the reviewing and setting aside of the impugned decisions, because the relevant decision makers have not been joined to the proceedings and accordingly have not weighed in on the alleged irregularity of the procurement process." We say this submission makes no sense, because the tribunal itself and in the public works, so not in that case, the tribunal itself, as in other matters, found that non-joinder concerning officials is bad. If the citations of the MECs on behalf of the department is sufficient, then that is sufficient. Otherwise, the SIU would never be able to obtain the relief in the form of setting aside a contract or that of the conduct of the department itself. For obvious reasons, many of these officials, we're not saying that that's the case here, are complicit in some misconduct. We are not alleging fraud or corruption in this matter at all, my lady. Pure legality point. We submit that none of the cases that have been relied upon by any of the respondents demonstrate that the officials have a direct and or substantial interest in the order sought. They seem to take issue with us that the SIU has not said why these officials have not been joined, or that it hasn't been sought to join them. We've dealt with this in our heads of argument. And as I said, the 11th respondent, their non-joined point is tied up with their contention that we should have proceeded by way of an action where they could have subpoenaed the persons who appointed them to give evidence. We say there's no reason why they couldn't have done so in these proceedings. Then, my lady, they rely on a matter, I think I referred to it earlier, which we say is wholly distinguishable, SIU versus Engineered System Solutions. I've given the citation. About the
11th respondent now.
Yes. 2022 brackets 5 SA 416 SCA.
Sorry, just give me a minute. It's SIU versus who?
Engineered Systems Solutions.
Okay.
ESS. 2022 brackets 5 SA 416 brackets SCA.
Okay.
Where the SA actually refused to admit Mr. du Toit's what is described as hearsay evidence, because there were no confirmatory affidavits from the officials concerned, we submit the case as distinguishable for at least 2 reasons. The one is in that case, my lady, the departments concerned were co-applicants. So it does seem to be quite strange. Don't put it any higher than that, no affidavits were filed on their behalf, and they sought the review. In this case, the responsible departments are cited as respondents, and like any of the respondents, they obviously had an election whether to file affidavits, whether to participate in the case or not, and they elected not to do so. In circumstances where serious allegations were made, one, that these lease agreements, which no one challenges, that the lease agreements with first and second respondents are invalid and unlawful, and that the contracts also were invalid. They don't take issue with it. And then the second distinguishable feature of our case is that we do, Mr. Du Toit does refer to Mr. Nkomo and Mr. Tolowe as in support of what he says. And Mr. Nkomo is quite a key witness in a sense, because he's from Treasury. And he's the one who points out that no procurement processes were followed. So that is not an inference or a conclusion that Mr. Du Toit thumbsucks. That one appears from the documentation that he collected and investigated upon, and your ladyship will recall also approached the respondents for their comments and their version, and there was a refusal or reluctance to cooperate. And then secondly, Mr. Nkomo confirms this in his affidavit. Perhaps the third distinguishing feature with that SEA case is that fraud and corruption was directly alleged, and certainly on the facts of that case, it seems as if there was no what one can call corroborating evidence in that regard. Oh, sorry, that's the other case that one of our colleagues also relies on, the public works method.
Public works is to do with the tender, right? That the respondent there gave information that had public works known, they would not have granted them the bid. Is that the one? Yes, that's I stand corrected, my lady. The 13th respondent refers to that matter, SIU versus National Minister in the Department of Public Works, brackets 2022, square brackets 2022, ZAST 19, brackets 26 August 2022. They also rely on that case for the unreasonable delay point. So
So, my lady, if I may just move on to another point, that is the application by the 7th respondent. And
are you done with
joined? I've done with
there's
joint.
one. Yeah, no, well, there's one more. You said the setting aside of contracts and then just an equitable, that's a relief you're claiming.
Yeah,
so,
if I may just interpose the issues with the 7th respondent.
Yes, okay.
When they say PAJA applies and that the tribunal is not a court of law. And then also the delay and estoppel points. We obviously didn't get an opportunity of dealing with this in our heads of argument, my lady, but we did deal with it in Mr. Du Toit's affidavit. It's at 101. 37. 101-37-56. And at paragraph 8, we refer to he refers to the issues that the 7th respondent now wish to argue before you, my lady. The delay point, the jurisdiction of the special tribunal, and the PAJA review point. We submit that has been dealt with by us and canvassed in relation to the delay, both in our affidavits and heads of argument. In relation to the jurisdiction of the special tribunal, the tribunal itself in its judgments that have been handed down, in relation to the applicability of PAJA, again, this tribunal has dealt with that in its judgment. So, my lady, if I may just refer you to some individual paragraphs in that affidavit. Paragraph 44, which is at 101-48. Paragraph.
It was answering affidavit to.
Yeah, that's in his answering affidavit, my lady. Then at paragraph 63, or 62, which is at 101-50, he says, in answer to their paragraph, say for admitting that the SIU did not itself take the decisions it seeks to review and set aside, these allegations are denied. In furtherance of the aforesaid denial, I point that in my founding affidavit, 1, I state that the application is brought also on behalf of the state, particularly GDOH and GDID, and 2, that the SIU was empowered by its constituting statute to pursue civil proceedings on behalf of organs of state pursuant to its appointment to investigate made by proclamation in the Government Gazette. and further on the facts as found in the SIU's own investigation led it to determining the existence of review grounds and being able to produce a review record in a manner akin to an organ of state in self-review. I may just add, just to add on there, my lady, I referred earlier to the case management meeting, which is unfortunately wasn't posted to case lines, the one of February, where the whole approach was fashioned by the judge president, and in response to complaints by some of the respondents as to the manner in which this review was brought, they were given the opportunity by way of 3512 inquiries to ask for further documentation, and there were several 3512 applications. With respect, all of them misdirected because it asked or referred to information that was already posted to case lines. And in our replies, which your lady will find on case lines, we referred to the relevant pages on case lines. At paragraph 64, at 101-51, we say, while the provisions
Sorry,
of...
Just a minute, please. Sorry, so that reference again?
The reference was at 60. About the case management meeting, my lady.
Yes.
That reference is in our replying affidavit.
Oh, okay.
I think I referred to it earlier.
Yes.
Because the minute wasn't uploaded to case lines.
Okay.
And then the next reference is paragraph 64, which is at 101-51, where we say, while the provisions of PAJA may have been applicable for a person affected by the decisions of GDID or GDOH to challenge them, the same does not apply when the provincial departments seek to review their own decisions or when the SIU does so, acting in accordance with its legislative mandate. And in its original, not original, but in its first answering affidavit, the seventh respondent, my lady, actually simply said that they noted that the SIU was proceeding or pursuing the review on the basis of the principle of legality, and then it said it's a matter for legal argument. They never contested it or said it is not permissible to do so, and that they will argue, and we submitted that to that extent they had originally acquiesced in the approach that we've adopted and which they now seem to challenge. The next paragraph is paragraph paragraph 68.
We're still dealing with the answering affidavit.
Yeah, this is still Mr. Du Toit's answering affidavit.
Mm-hmm.
Yeah, at 67, which is at 101-52, in paragraph 15 of my founding affidavit, I state that this application is pursued in the SIU's own name and also on behalf of the GDOH and GDID. This allegation was not placed in issue by the seventh respondent in its answering affidavit. Then the following paragraph.
It was not placed in issue in which affidavit?
In the 7th respondent's first answering affidavit.
Oh, first answering affidavit.
Yeah. I think the one of 29 July or 1 August.
Mm-hmm.
Then at 68, Mr. De Tooy says the SIU is not a private person that, such as an unsuccessful tenderer reviewing the decision of an organ of state. It itself is an organ of state and legislatively empowered by Section 41C to institute and conduct civil proceedings. The Constitutional Court had made it clear that a state institution under self-review may only proceed by way of the principle of legality. Then 69, the SIU embarks upon review proceedings such as these following upon a comprehensive investigation it conducts wherein it obtains documents and statements from officials in the state institution under investigation. It thus compiles its own review record in a manner akin to a self-review. Then at paragraph 70, my lady, in terms of the authority, he says, finally, the special tribunal has already found in both special SIU v MEC for Treasury Free State Province, that was on the 31st of January this year, and in SIU versus Patalizwe Training Institute and another on the 18th of May, I think the SIU in the Eastern Cape, that the principle of legality is correctly relied on by the SIU when it pursues review applications in the special tribunal as it's a proceeding akin to a self-review and not in furtherance of an administrative law right. And then the last reference, my lady, is on the status of the special tribunal at paragraph 77, which is one of the new points now raised by the 7th, at 101-54. The special tribunal has previously found that it is a court of a similar status to the High Court and is empowered to handle review matters and grant just and equitable relief in terms of Section 172(1)(b) of the Constitution. So, my lady, those are the points in answer to the 7th. So, what remains for me, my lady, is to deal with the setting aside of the contracts and the just and equitable relief that we seek. Yeah. My lady, may I request an adjournment of no more than 15 minutes, just so that I can gather my thoughts and perhaps move a bit quicker and even close today with our arguments, my lady.
Yeah. I take it none of the other respondents have a problem with that, or has anyone got an objection to it?
No objection, my lady.
Okay, good. All right, we'll take a short adjournment. 15 minutes, 25 to 3. So we say 10 to 3?
As the court pleases.
Thank you. We'll adjourn now. Okay, are we all back? Mr. Arendse, are you with us?
Yes, my lady, thank you.
Good. All right, if everybody's back, we can continue.
Thank you, my lady. So, my lady, we're dealing now with the legality review proper, the setting aside of the contracts. We deal with it. Of course, if I may just say by way of context, my lady, I'm not going to repeat what we described as uncontroverted evidence, assertions, allegations made by Mr. Du Toit, which has not been controverted by the respondents, despite having had ample opportunity to do so. We submitted that's hardened into fact, into evidence, and your ladyship will take note of that. And we submitted that those so-called common cause facts themselves implicate the individual respondents who oppose this application as having been complicit in several breaches and contraventions of the procurement legislation and Section 217 of the Constitution. So may I then commence by referring your ladyship to our heads of argument 054-181. We deal with the formal breaches or contraventions of the applicable procurement regime, which flow from those facts which I've highlighted at the outset, and which are also highlighted in Mr. Du Toit's affidavit and in your heads of argument. So we make the point at paragraph 61 which is a repeat of a point I made earlier, is that even in an emergency situation, in fact, thankfully we will never be in another state of emergency, but even in an emergency kind of situation brought about by COVID, the compliance with the Constitution, the PFMA and other applicable provisions, and Treasury, importantly Treasury regulations, still had to be complied with. So at paragraph 62, my lady, we refer to the important case decided in this tribunal, the Chachulani Group Investment Holdings and others, decided on the 14th of August 2021. It's at footnote 74, my lady of our heads, where it was said that even when a deviation on the grounds of emergency is permitted, such deviation must still comply with Section 217 requirements. If Section 217 is not complied with, opportunity is created for abuse and exploitation of the fiscus. There we referred 63 to Section 38(1)(a)(3) of PFMA. The PFMA also requires the evaluation of major capital projects such as this one by the Accounting Authority of GDOH before proceeding with a final decision to proceed. And that's prescribed by Section 38(1)(a) Roman 4. As we have already shown, works on the hospital were months underway before the HOD of GDOH knew of the ultimate costs involved. So PFMA was not complied with. At paragraph 64, notwithstanding the National Treasury under Section 76 of the PFMA having adopted emergency provisions pertaining to COVID-19 related procurement necessitated by COVID-19 pandemic, this did not and could not detract from the constitutional imperatives relating to procurement. Some of the relevant instructions it issued, however, provided for departures from the usual stringent procedures. At 64.1, National Treasury Instruction 7 of 2020, where it provided that because of COVID and the need to be, the state to be responsive and flexible, whilst ensuring value for money and minimizing the risk of fraud, corruption, negligence, error, incapacity, and to ensure that internal control mechanisms of the department consider certain aspects as mentioned in that practice note. But then it goes on to say, my lady, very importantly, it further provides in paragraph 7.9 of that Treasury practice note that even where emergency procurement is embarked upon, the principles of fairness, equity, transparency, competitiveness, and cost effectiveness must be maintained. It further obliges accounting officers, accounting authorities to ensure that an audit of emergency transaction is made a priority to provide assurance on the value for money spent during emergency operations and to identify actions to strengthen controls in emergency transactions. Then also National Treasury Instruction 5 of 2020 confirms that all existing norms and standards, including those pertaining to deviations were required to be followed. Paragraph 3.6 of Practice Note 3 reflects on the variation and expanding thresholds of contracts, which was by virtue of this instruction now increased to 30% or 30 million for construction-related goods, works or services. Importantly, my lady, it is stated that any contract variation, extension or expansion in excess of these revised thresholds will only be allowed in exceptional cases, subject to prior written approval of the relevant treasury. And just to pause there, we know from Mr. Nkomo's affidavit, which I referred to earlier, which is when? I know I gave you the reference earlier.
Yes.
None of this was followed. National Treasury Instruction 64.5, 8 of 2019, dated 19 March, which is just at the outset of the pandemic in March, required institutions to report 406 of that. Required institutions to report to the relevant treasury any emergency procurement within 30 days. So at paragraph 65, my lady, 054-185, contrary to paragraph 9.1.18.1.1 of the GDID's own SCM policy, the so-called other means relied upon by GDID for appointing the PSPs and contractors were not based on price quotations or negotiations. Because the refurbishment project was not put out to tender, even in the ordinary course where the specific COVID-19 related instructions were not operable, the applicable legislative regime required of the provincial departments embarking on the refurbishment of the hospital inter alia to, 1, record the reasons for deviation from inviting competitive bids and obtain approval from the accounting officer required by Treasury Regulation 16A6.4 to report the relevant treasury and to the relevant treasury and Auditor General within 10 working days deviation of goods and services above 1 million required by National Treasury Regulation 16A64. This note, follow the framework for the planning, design and execution of infrastructure project, obtain prior written approval for the departure, to invite competitive bids, comply with the framework for infrastructure delivery.
Not necessary to read the whole affidavit, Mr. Arendse. Just refer me to the paragraph.
So in 67, we conclude that these requirements were not complied with, and instead the contractors and PSPs were appointed and commenced work without compliant procurement process having been followed. We had referred to Mr. Nkomo, who's the Director of Infrastructure Performance at Gauteng Treasury. The founding affidavit 07878 para 130 to 07890 paragraph 161. And this stands unchallenged, my lady. No approval had ever been sought or granted by. In fact, Treasury warned GDOH that it did not regard the construction of new facilities and or major reserve refurbishments as being suitable options to be used in the face of the pandemic. Reporting of the expenditure happened well after the 10 working days after the appointment letters, and no pre-approval for a variation or expanding of the contracts was sought, let alone granted. At 70, the fact that PSPs and contractors were appointed at the same time gives rise to further inconsistencies with procurement regulations. And we set out those reasons at 70.2 to 70.4. So at this point, just to underscore the point, my lady, that at this point, Ms. Mutara's report has got nothing to do with all these, with the failure to comply with procurement legislation, with treasury instructions, etc. Just a blatant breach of the law and of the Constitution. Of course, my colleagues acting for some of the respondents will deal with their defenses, the one being that they are just sort of innocent third parties in this whole scenario, and we cannot now demand the money back, or in our case now the profits as a result. Some kind of estoppel argument. Then at 71, we say that although GDOH and GDID purported to procure the lease agreement with AngloGold in terms of Treasury Regulation 16A64 on an emergency basis, the fact of the matter is that the SCM prescripts pertaining to unsolicited bids were not followed, and 71.2, all that is unchallenged, my lady. So because of all that, my lady, neither GDOH or GDID conducted any project feasibility study, which would also have been a fundamental requirement. So we make the point that if your ladyship is to allow a state of affairs, notwithstanding a prevailing emergency situation, whereby service providers and contractors can commence work for the state on a multi-million rand project without any budget, scope of works, clear instructions or approvals from the relevant treasury, and on the basis of a one-page conditional appointment letter, then the entire procurement system in this country may well be rendered non-existent, and Section 217 of the Constitution will bear no meaning. Which we know from colloquially and from reading the newspapers was the case, but in this case, fortunately, the SIU, through diligent and deep-seated investigation, brought this issue to the attention of the court, and we submit that your ladyship won't lightly ignore the failure to comply with the legislative framework. Then our next leg, my lady, is the absence of rationality. That's at 054190-190. We've already dealt with the lease agreements, which
Yes, I think it's quite extensively covered, you know, with why you say it was irrational and therefore false to be set aside.
Yes, ma'am. Then just in relation to the individual respondents, we deal with that at paragraph 84 at 054-194. In relation to the fourth respondent, my lady, at 84.1, the fourth respondent is a firm of architects. They don't have a multidisciplinary practice, and they have no quantity surveyors as directors, and was not listed on the GDI panel to provide quantity surveying services. Yet it was appointed as the quantity surveyor on the project. There was no paperwork identifying how the PSPs were selected from the companies also listed on the panel, used by the GDID and or special skills these particular professionals held. Because if I recall, and obviously if I got it wrong, then I stand corrected. But those on the panel, they say that they were on a panel. It's a pre-approved panel, and provided they were appointed fairly on some kind of a rotational basis, then that would have been in order and complied with certainly with the GDID's procurement during this time of COVID. But as we say in 84.2, there's no, they don't offer any paperwork. They don't tell us how they were identified and how they were identified and others were not identified or appointed. The 84.4, there was also a failure to brief properly the PSP as to what was required from them before they were appointed. No project costing or pricing or scope of works was reflected in the appointment letters. And the service level agreements, which some of the respondents attach and refer to, doesn't set out any details or specifics. In fact, your ladyship will see from them that they, in many instances, just blank. So literally a blank check, not filled out or completed. And at 84.6, we make the point that the 5 PSPs were not appointed by means of a manual rotation basis. So although they were appointed at 84.7, subject to the finalization of an agreement to acquire the hospital being reached, they actually commenced work before that was done, my lady. And before that such an agreement, in fact, no such agreement exists still to this day. And then we submitted 84.8, the selection of whether it's the third or the fourth respondent was irrational, as it failed to execute its duties competently, and they had no regard to the concept of value for money, as evidenced by its high cost estimates when compared to other projects. They seem to have misunderstood their role in the project and abdicated their responsibilities for overall management thereof. Then at 84.9, any purported extension of the panel of PSPs would not have been lawful. We set out these reasons at. Then that's for the PSPs, and then as regards the contractors, already we similarly make the point that that is rational.
Yeah.
Only one of them, that's the 11th, Ikusasa, was on the panel of GDID contractors and thus had been previously vetted. The joint venture of the 8th and 9th, which may explain why they're absent and not participating in these proceedings, was not in possession of a CIDB ranking high enough to enable them to perform work in excess of 60 million rand, which is the ultimate contract value. There was a failure to invite contractors to submit a tender for the work to be performed. Site access letters were issued to the contractors on 16 April 2020, nearly 2 months before any of them were provided with appointment letters that included costing. Contractors were, in the circumstances, permitted to access and commence work on the premises without having any legal authority to do so. Mentioned previously, 85.5, in the appointment letters, no indication of contract amount, bill of quantities applicable, or scope of work. Yet, they commenced with the works. Quite extraordinary. Purchase orders were only issued in late June 2020, my lady, but payments had already commenced in April 2020. That's at 85.6. So overall at 86, there was a complete failure on the part of GDIH or GDID to manage the contract price. So despite the fact, and I'm moving quickly to paragraph 90, my lady, at 054-199, despite the fact that GPT, that Gauteng Treasury disapproved the very concept of the refurbishment of the hospital from as early as 31 March 2020, payments were still made to the PSPs and contractors concerned. Not only did the cost snowball from an estimated 50 million rand to an amount more than 10 times greater, but the hospital took at least 16 months longer than envisaged to be able to be used, only in part, and was unable to be utilized during the first and second waves and much of the third wave of the COVID-19 pandemic, which was the very purpose why a lease agreement was entered into with the hospital and why it needed to be refurbished. So the whole aim and purpose and rationale behind the project didn't materialize because it wasn't thought through, it wasn't planned, it wasn't discussed on a rational basis. And then at 92, we make a concluding remarks, my lady, that the appointments of the 3rd to 14th respondents to provide refurbishment and renovation works or render such services to the provincial departments were inconsistent with Section 2.7 of the Constitution. Then we move on to, as I mentioned earlier, my lady, we do not abandon the overcharging aspect of the case, but raise it as a review ground and that's at 054-200, my lady. At 93, we say a further ground of review relied upon by the SIU for setting aside the contracts of 3rd to 14th respondents is the overcharging or unreasonable / non-market related pricing adopted by them.
Yes, now it's really not necessary to read all of that. I have actually read it. Just refer me to which paragraph you particularly want me to take into account.
May I just, as it were, go off my heads, my lady, and just refer you to the highlights of the Motara report, which is referred to by Mr. Du Toit, and refer to some of those references. It's 011.
That was in his supplementary affidavit, was it not?
Yes, my lady.
Yes, now I've read that as well. He then reproduces that schedule, and he also does the correction, indicates the correction in the figures.
Thank you, my lady.
I've seen that.
So that's 011-65 to 011-70, and in particular paragraphs 21 and 22. And also our replying affidavit, which is your ladyship had actually picked it up already. There's an expenditure report where comparisons are made with similar projects during COVID, not before or after, but during COVID, which indicates, to put it mildly, a differential in the charges made here by the individual respondents compared to other hospitals. That's at 100-196.
196.
Yeah.
Okay, good. Yes, I've seen that as well.
So my lady, those are our points in relation to the setting aside of the contracts in the grounds on which we submit. Your ladyship will find that these contracts were concluded in breach of the relevant legislation, the Treasury prescripts 217 of the Constitution, for lack of any rationality, and also on the grounds of overcharging. We now move to the just and equitable relief. It is 054225 of our heads. That's at paragraph 130, my lady. where we say in the event that your ladyship is with us and declares and sets aside these contracts, it would become necessary to determine the consequences of such unlawful and or unconstitutional conduct. This tribunal has already said and that is in the SIU v MEC for Treasury Free State Province case. It's at footnote 195, my lady. The following: just and equitable relief is discretionary in nature. Its purpose is to preempt or correct or reverse an improper administrative action. In this regard, the Constitutional Court in Bengenyama stated that, quote, the apparent rigor of declaring conduct in conflict with the Constitution unlawful is ameliorated by providing for just and equitable remedy in its wake. And then we say that at paragraph 131, that having considered the answering affidavits filed by the opposing respondents, and notwithstanding what we submit were merely bold, vague, and sketchy denials of overcharging on their part, in order to avoid protracted trial proceedings, the SIU decided to seek an order for the alternative relief referred to in paragraph 7 of the amended notice of motion, which I also referred to in my opening address. In other words, we will ask for an order compelling 3rd to 14 respondents to disgorge their profits, the amount to be determined through a statement and debatement process. At this time, we cannot quantify the amount of profit each respondent made. Safe to say that the 4th respondent contends that it made a loss. The 7th respondent alleges that it applied discounted rates, and the 10th respondent's expert says its profit was 12.13%. Such relief has been found by this tribunal to be competent under 1721B of the Constitution, and is now regarded as prompt. Recently, the Special Tribunal has gone further. It's at paragraph 134 and held in Patilizwe at paragraphs 31 and 32. And I quote, it has become trite that rendering services under an irregular tender does not give a tenderer the right to retain profits accrued from the tender. The Constitutional Court has permitted a tenderer to retain profits derived from an unlawful tender only under exceptional circumstances. Even if I were to find that Patilizwe did render the services as alleged, it does not establish exceptional circumstances that justify the exercise of the tribunal's discretion to allow it to derive full payment for the services. At best for Patilizwe, in accordance with the no profit, no loss principle enunciated in all pay, it is entitled to costs incurred when rendering services under the extended tender. Yeah, I think we also referred, Your Ladyship, to the Seyangena matter. In the present case, Seyangena was rightly found by the High Court to have been complicit to the corruption, impropriety, and maladministration consistent with the notions of justice and equity that it should be allowed to profit from the unlawful procurement contracts. Furthermore, even innocent counterparties are not generally entitled to benefit and profit from an unlawful contract. That's paragraph 44 of Siangena. And at 135, we submit, my lady, that there's even higher authority for this proposition, the Constitutional Court in All Pay. At paragraph 67 of that case, it is true that any invalidation of the existing contract as a result of the invalid tender should not result in any loss to the service provider. The converse, however, is also true. It has no right to benefit from an unlawful contract, and any benefit that it may derive should not be beyond public scrutiny. And then in a more recent case, the Constitutional Court also in Shabangu, that's at paragraph 136, where the court recognized that an unjust financial benefit flowing from an invalid contract may be recovered either by enrichment or what has become known as the no profit principle. And we deal a bit with Shabangu at 137, and we submit, my lady, in closing, that a proper case has been made out, given the prevailing case law, given the gross non-compliance with procurement processes, the irrationality and the overcharging, and that profits obtained through such a fatally flawed process should not be permitted to be retained by any of the respondents. My lady, those are submissions to the extent that we have not dealt with any of the points raised more recently by some of our colleagues in heads filed late and or affidavits filed late, in the event that your ladyship has admitted them into the record and condoned their late filing, which we didn't oppose. We will deal with them in reply, my lady.
Sorry, in reply?
Yes, if we haven't dealt with any of these, we don't waive the right or say that those points are valid. We just ask for permission to deal with them later.
Yes, it's fine. Are those your submissions, Mr. Arendse?
Yes, my lady, and of course, we ask for costs jointly and severally against those of the respondents who have opposed the application, the costs of two counsel, including costs of senior counsel, where so employed.
Thank you. Right. I think the next person would be for the third respondent, Mr. van der Vyver. I'm not sure if you want to start now or you want to start in the morning.
My lady, given the limited approach that the third respondent has adopted, it might be prudent for me to just deal with it right now. Initially, I thought it might have been better to go after some of the other respondents, but I might as well get it over with so that somebody with a more lengthy argument can take it in the morning if your ladyship is comfortable with it.
I'm fine. I'm fine with that. I just didn't want you to feel constrained. We've got 25 minutes, and are you going to finish in 25 minutes?
I can't guarantee that, but I think so.
Well, let's try.
My lady, I intend to structure the argument dealing with it in 4 topics. First, to explain or highlight the role that the third respondent fulfilled. And then the second, to relate to the dispute of fact and the non-joinder. Thirdly, I would just like to point out that according to the third respondent, there is a discrepancy in the report filed by the applicant. And the last issue is the issue of costs. So your ladyship would have noted from the answering affidavit filed by the third respondent that firstly, it was registered as a supplier on the central database on GD, and it was also registered as a vendor on GDID's vendor list. And in this particular project, it was appointed as the project manager to ensure that the scope of work that was to be rendered was in fact rendered. Now, the distinction that the third respondent highlights here is that it wasn't as per the norm where the project manager has a quantity surveyor in its team. Here, the fourth respondent was appointed as the quantity surveyor. Now, it wasn't part of the third respondent's obligations to verify prices or rates. And it explains that where its signature...
Give me a minute, please.
Right, please, my lady.
So you say he was the quantity surveyor and?
No, he was not the quantity surveyor. The fourth respondent was the appointed quantity surveyor. So that and that is material. Correct, my lady. So what he tells the court is in this particular project, it wasn't the obligation of the third respondent to validate rates or prices. And where its signature appeared on payment certificates that had been issued, it appeared so together with the signatures of the other PSP members on the team, but it verified that the work that was to have been done was done. For example, if there were to be 10 ICU beds in Ward A, the project manager would say, well, there are 10 there, so he signed the certificate. Now, it's not the third respondent's case that the fourth respondent did not do its job. That is not what it's saying. What it's saying is it played no role in verifying or validating the rates. It contends that its own appointment, the third respondent's appointment, was not irregular because it was already on the panel and there was no need for it to go out to tender to be appointed. Now, it becomes important when one has regard to whatever ruling your ladyship makes, but when one has regard to the cost order that needs to follow. Because the third respondent's contention is it had no role to play in any alleged overcharging that may have occurred. And I need to reiterate the point that it's not saying that there were overcharges that did in fact occur. It explains furthermore that there's a reason why it did not file the expert's report, because it wasn't involved in the actual prices. So that's why it made the statement that it would cite by the experts filed by the other respondents. Now, the applicant tends to argue or set out in the papers that when one looks at the SLA, that it was the third respondent's responsibility by having regard to clause 7.4 of the SLA. Now, the SLA, I can just give your ladyship the reference where one can find that on case lines. That is at 028-623. But in essence, the applicant intends to rely on an overall clause which says that the project manager will accept full responsibility for the design and execution of the project as a whole. But one cannot put that or any overcharging at the door of the project manager simply by having regard to that specific clause. The fourth respondent's SLA one can find on page 028707. And that at clause 6 and 7 describes the fourth respondent's obligations as being that of the quantity surveyor. Third respondent's one is defined as the project manager. Now, the applicant in its heads of argument at paragraph 95 made the submission that the third respondent effectively conceded prayers 1 to 4 of the notice of motion. My lady, that is not correct. One needs to view it in context. What is said at paragraph 7 of the answering affidavit at 092-8.
Just a minute, please. Sorry, you were saying you must look at that in context?
Yes, so it's not a concession that they are entitled to the relief that they seek. It's explained. It says the third respondent wasn't required to tender because it was on the registered lists, and it's got no knowledge of the contractor's appointments, and therefore it denies any wrongdoing. So there's no concession. That the fact remains that they're not in a position to dispute it.
Yeah,
but I just wanted.
That's basically what he said. It was in your heads, I think. You said you're not in a position to dispute it.
But that's correct. I've got no difficulty with that. But it's not a concession that they're entitled to the relief that they seek. Now,
just a minute. Yeah.
If I move on, my lady, to dealing with the dispute of fact and the non-joinder, one must look at where the applicant started this whole process. In its initial notice of motion and founding affidavit, it made it quite clear that it was going to embark on a two-pronged approach, a part A and a part B, because it was fully aware of the fact that there would be disputes of fact. We've now have two additional expert reports, albeit a preliminary report and another expert report, which clearly highlights disputes of fact. But what happened was the applicant changed course halfway through, and it filed a supplementary affidavit together with an amended notice of motion, claiming monetary relief to the rand and cent against the respondents. And it persisted with this until this morning when Mr. Arendse indicated that, well, now they are going to carry on with the, I think it's press 7, to say that it must be referred.
Oh, he did say that in his heads. That was mentioned in his heads as well.
Well, may please you, my lady. Okay, so if it's in the heads, that's fine. But what they've done is they've persisted with claiming the just and equitable relief and the monetary relief from all of the respondents, and they've necessitated that the third respondent come to the party and file its affidavits, whereas if it remained on a Part A, Part B, the third respondent may in all likelihood would not have been party to these proceedings for this week. And the concession that there are disputes of fact which were foreseeable from the third respondent's point of view, we would argue that it amounts to an abuse that the applicant has instituted, and I would like to tie that to the non.
I understand. You say it's an abuse to do what? To amend your notice of motion?
No, my lady. If you foresaw that there's a dispute of fact, and you then carry on in motion proceedings, and you don't, when those disputes crystallize, at the very latest when the answering affidavits were filed, say, well, okay, let's refer the entire matter to trial. Or alternatively say, well, I will only persist with Part A now. And if you tie that to the non-joinder, because the third respondent named the decision makers, they by name, they are in the answering affidavit paragraph 19. They haven't been joined. And the applicant contends, well, it's not a joinder of necessity, but the authority that they rely on says, well, if you will be affected prejudicially by the order that is given. And in their own heads of argument at paragraph 20.5, he says, or the applicant says, well, the reason why there are no confirmatory affidavits of these decision makers are because they've either resigned, they've been suspended, or they are pending disciplinary hearings.
But are we to ignore the fundamental principles laid down now through the cases, you know, about the grounds and requirements for joining somebody? And surely the most basic question is, do these so-called decision makers, employees of the 15th and 16th respondents, have a direct and substantial interest in the outcome of this litigation? What interest would they have in it? And if they don't, so what is the necessity of joining them?
Well, my lady, the interest they are going to have is if your ladyship would have to find that some or all of them didn't do what they were supposed to have done, and that is going to affect them in their personal capacities.
Well, you know, that's a different argument, but for the purposes of the outcome of this litigation, what interest can they possibly have other than hurt feelings or some perception that they've been defamed in some way or the other? And I understand there's disciplinary proceedings against them at the moment, which I am quite sure will touch on whether or not they did what they were employed to do.
Well, I can take the argument no further than to say they'd be affected in their personal capacities, in that your ladyship would have a finding, most probably make a finding that there was some wrongdoing on their side. Okay. But if one, and the argument by the applicant that one could have approached the the decision makers for confirmatory affidavits, my lady, in response to that, and that is why I say I would like to tie the dispute of fact together with the non-joinder, is if the matter was to go to trial, you'd be then in a position to subpoena these decision makers to appear before court and give evidence, which would then also expose them to cross-examination. So it is convenient to persist with motion proceedings where you can't cross-examine any of your experts. Your hearsay argument from Mr. Totoy's affidavit, you give credence to that argument, and then you also cannot test the versions of the decision makers. So, my lady, the point I'm trying to make is the approach that the applicant has adopted from the third respondent's perspective amounts to an abuse, and they ought to have approached the court to refer the second part of the relief they sought to trial much sooner. And even if your ladyship finds that ought not to have happened, from the third respondent's perspective, we would submit that is good enough grounds not to award costs against the third respondent. Alrighty, then lastly, I would just like to
Yes. Thank you. You may continue.
already the applicant's entire expert's report, they tell the court, well, it's based on a rates comparison because they claim that there wasn't sufficient information to do a proper check on the bills of quantities or a remeasure. Now, one finds that at 087-3. And then they state that the figures that they've used have been justified based on hospital tenders that occurred during 2020. Now, several of the respondents challenged these rates that they used because there were no detail or particularity as to where that was obtained from. And the response to that by the applicant, which your ladyship finds in the replying affidavit at paragraph 421.30, which is on page or case lines 100-112.
And this is you say the replying affidavit.
Yes. What they say, what the applicant says is it says, well, the hospital tenders and the information was shared with them by other contractors on condition that it's treated as confidential. So there's a difficulty in challenging the rates that they used or to validate at least that they were 2020 tenders that related to hospital work. If one goes to the expert report, and I'm going to give your ladyship the case lines reference. It's part of the mechanical experts report on 087-180. And it's under paragraph 4.8, which has got a heading bills of quantities and remeasured scope. And there's the second bullet there after there's 3 short paragraphs there, but it says the following. It says, the Sintercare Hospital project completed out by Zutari in 2020. And the important part here is brackets tendered in 2018. So the point I'm simply trying to make is the credibility of the report is in question if they say that they used rates for hospital projects that were tendered in 2020, if one can clearly see on their own report, the tender figures for at least the Sintercare one appears to be 2018. So it's our submission that ought to throw out the entire report. My lady, that in a nutshell is the third respondent's submissions. And I just want to reiterate on the aspect of costs. Had the applicant taken a different approach, given the foreseeable disputes of fact, the third respondent may very well have set out of these motion proceedings for the time being. And even if your ladyship finds that it was unlawful and it should be set aside, given the role that the third respondent played, and that it played no role in determining rates or figures or anything to that sort, in any event, there shouldn't be an order at this stage that the third respondent pay any costs.
Thank you, Mr. van der Verwe. Are those your submissions?
Those are my submissions, my lady, with 7 minutes to spare.
Oh, well done. Just one question that I want to ask is, so from what I gather, is you're saying you can't dispute the relief they claim, although you're not saying they're entitled to it. So you're not disputing that there was a breach or contravention of procurement legislation, of the Constitution, of the PFMA, and so on. You're not disputing that in fact was the case.
Yeah, I'm not putting up anything to gainsay that. They're basically claiming no knowledge of that, my lady, if that makes sense.
Thank you, Mr. van der Verwe.
Thank you, my lady.
Right, we have almost reached the end of the day. I think, Mr. Killer, you will get your chance tomorrow morning.
Thank you, my lady. Thank you, my lady. Although, my lady, if the situation permits, I can allow, in fact, the other respondent to take my place and then come thereafter.
Sorry, who would you ask? Sorry, I didn't quite catch you.
I'm saying, my lady, for the purposes of the fourth respondent, if in fact the court allows us, would like to occupy another space, in fact, in the form of dealing with this issue, we can come after the seventh respondent. We don't mind.
After the seventh respondent.
Even the eighth is fine, my lady, so that we can get the proper instructions. And as far as
perhaps you can just chat. All of you can stay on the line once I leave, and just chat with each other and let me know what the arrangement is tomorrow morning.
Thank you, my lady. I appreciate it.
All right. For now, I think we will adjourn for the day's proceedings, and we'll see you all tomorrow.
Thank you, my lady.
Thank you.
Thank you, my lady.